All right, are we ready, staff? Can I start? Okay, welcome back. In accordance with sections 45 and 53 of the Planning Act as amended, this meeting, Committee Adjustments, City of Toronto is called to order. I am the chair, Larry Swartz is my name, and to my far left we have Mr. Marziari, near left Ms. Casson, near right Mr. Allison, far right Mr. Kaboo. Committee of Adjustment considers applications for variances, lawful non-conforming use extensions or alterations, and consent to sever property to create new lots. We acknowledge the land we are meeting on is a traditional territory of many nations, including Mississaugas of the Credit, Anishinaabe, Chippewa, and Haudenosaunee, and the Wendat peoples, and is now home to diverse First Nations, Inuit, Métis people. It's covered by Treaty 13 in Toronto with the Mississaugas of the Credit. This hearing is conducted in a hybrid format with some participants joining in person, others virtually via WebEx. Meetings are streamed live on Toronto City Planning YouTube channel for public viewing. Participants joining virtually will be muted on entry and unmuted when their item is called, and please keep your devices muted until you are called upon to speak. Those participating via video will temporarily be upgraded to panelist status during their speaking time. Attendees must submit a written request for a copy of decision by email if participating virtually. If you disagree with the committee's decision, you may be eligible to appeal to TLAB, which is Toronto Local Appeal Body, or in some cases, Ontario Land Tribunal, but this is restricted based on changes to the Planning Act. Each speaker, including applicants, will have up to 5 minutes to address the committee. Please stay focused on the application's relevant matters. Committee may defer applications that have been substantially revised to ensure accuracy and proper notice to all parties. For uncontested applications, the agent or applicant may proceed without a presentation unless the committee requests one. We will proceed by calling each item in the order listed on the agenda. So, in terms of the declarations of interest, do we have declarations of interest from any panel members this afternoon? No.
Point of order, would you be able to raise the the speaker, please? Could you turn up the speaker volume, please? Thank you.
And Madam Acting Deputy Secretary Treasurer, do we have any deferral requests for the afternoon session?
No, we don't.
Okay, thank you. And I take it there's no further items closed, so let us get on with the hearings, which is beginning in the afternoon with item 12. Item 12 is 1 Lionel Heights Crescent. There's 4 variances. This is to construct a garage and addition, interior alteration, and underpin an existing dwelling. Application was deferred from June 20th. Got 3 letters of support. We've got a staff report. Staff report recommends that it be developed substantially in accordance with west side elevation and so forth. We've got transportation reports. The variances deal with rear side yard setback, driveway width, building length, building depth. Okay. So do we have a applicant here either in person or on the line? Where is our applicant agent? Are you here in person? Make sure you turn on the microphone, try to put it close to your mouth. So
Hello?
hear you. And we don't have anybody opposed to this one, I take it, right? So just state your name, state your address, and then pause once you've done that.
John Lorero, 1 Lionel Heights Crescent.
All right. So let me look at, now that we've heard that, Do you have any changes to your application before you get going?
No.
Okay. Now let me just canvass my panel members to see when they shake their heads, that's actually a good thing because they don't really need to hear from you. Unless you want to, of course. So what I'm saying to you is this could be your lucky day. You don't really
Amazing.
have to present.
That's awesome.
If you've spent a lot of time, you can sort of highlight, the first sentence or so, but otherwise we don't really need to hear from you.
Okay.
Okay?
Fair enough, yeah.
All right, so let's go into committee. Just, bear with us. Committee questions of the, well, I take there's no questions of the applicant, right? Then, no, let's go into committee. We have a motion. I see Mr. Allison, Mr. Kaboo. Mr. Kaboo is making a motion, I think. Let him do it. And we'll go to Mr. Allison to second it.
Thank you, Mr. Chair. Based on the planning staff recommendations, and then the application was originally deferred in June 2024. So, based on the recommendation that the proposal be developed substantially in accordance with the west side elevation drawing and north side elevation drawing submitted to the Committee of Adjustment, I'm happy to propose that we approve this application subject to this amendment.
All righty, and seconded by Mr. Allison.
Just to actually, I did notice there were some transportation recommendations.
Yeah.
Yes,
I-
if that's okay.
Chair, we-
But there was a follow-up report on August 12th, clearing any
Oh, clear.
condition.
Thank you. My apologies. And I'm happy to second the motion.
All right. So we got a motion, we got a seconded. All those in favor? And it's unanimous. So congratulations to
Thank you.
people on Lionel Heights. Nice street that I didn't grow up very far from. So I love Don Mills, so it's like I used to play baseball at Broadlands. Yeah, okay. That's it.
All right, thank you. Have a great day.
Thank you very much.
Now we're on to the next one, which is item 13. And that is 103 Owen Boulevard, which I also know. 12 variances to construct new dwelling, pool, a cabana, and in the rear yard. This application was deferred on July 4th to ensure that all variances are in the public notice. We've got an arborist report, forestry reports. We've got a letter of objection. We've got ravine reports. Of the variances, they deal with height of the building, height of the side yard, exterior main walls, proposed height of side yard, exterior main walls, proposed east side yard setback. We've got nobody in opposition, although we do have a letter of objection on file. There is nobody in opposition here, is there? All right. And we have a applicant agent somewhere on the phone? All right, let them go.
Yes, sir. Can you hear me?
Yes.
Okay, perfect. I don't see myself on video. Not sure if you can see me, but my name is Michael Walker. I work for Green City Communities Inc., located at 85 Renfrew Drive in Markham, Ontario.
All right. So before you get going, any changes to your application?
No immediate changes. As you'll see noted on the staff recommendation report, we were deferred from the July. I'm getting a lot of feedback. Are you guys hearing that as well?
Oh, that's right. Yep, staff reports. Okay. Yeah, there are staff reports, and I didn't mention that. So let me just see what these staff.
So there's no immediate change to the design in front of committee today.
But just let me look,
Basically,
let me look at the committee just because. Sorry, I didn't outline the staff report, so I better just check with the committee. I don't know what the staff report says because I haven't read it. But I want to check with the committee if they want to hear from this applicant or not. They do, okay. Because the staff report probably says something important, and somehow I missed it. So I'm sorry about that.
Yeah, I just want the applicant to clarify if he's read the planning staff report and if he agrees with it.
Okay, good. All right, so why don't you start with that? Have you read the planning staff report, and do you agree with it?
We have read the report and we are in agreement, and we will revise the design to not be a flat or shallow roof, which will allow the maximum height to be up to 10 meters. So the elimination of item number 1 is okay with us.
All right. So do you still want to hear from him? You don't? I'm deferring to my esteemed panelists because I, as only the chair, can't do everything. So I don't think anybody really wants to hear, or do they? Marziari, nobody is that keen on hearing your full-blown presentation. If you want to, so you've just identified what you're complying with the staff report. So we would probably need a motion that would reflect on that. But other than that, I think unless you want to do a full-blown presentation, we're happy to go into committee. So do you want to let us go into committee, or do you have anything else you need to say about this?
I'm happy to go into committee and answer any questions that you may have.
Okay. People are satisfied they got all the questions answered? So let's go into committee. And in committee, if there's either any discussion, and I think there is none, so let's look to a motion. And nobody wants to bring a motion? You wanted to go into committee. Mr. Marziari.
Through you, Mr. Chair, I'd be happy to make a motion to approve this application as amended. So amendment is elimination of variance number 1. I believe with this amendment, the application meets the 4 tests, and also subject to planning staff recommendation.
Right. Okay. Just
And also forestry memo. Number
Okay.
2, correct.
so that's the staff report of August 9th. Right? Okay, so seconder for this motion? Ms. Casson. And so that's, so it's clear, staff have that, right? The elimination of variance 1, proposed and subject to the conditions, the proposed side yard main wall height. So
Conditions include transportation.
did we get transportation in there?
I have transportation, forestry.
Sorry, that is correct. So subject to transportation report as
Was there anything in that transportation?
We have a memo from July 26th, and oh yeah, it is referencing the earlier memo from June
referencing the old
27th.
memo.
Right, so it is subject to transportation as well.
There are
Okay.
some, there are some
Yeah.
conditions. Yeah.
Yeah, that's true. The site plan drawing 1, cabana ground floor. Am I getting this right? Yes. And the
That's right.
public, okay. The applicant, no objections, illustrate dimensions within the public right-of-way. Add notation on the site plan drawings. Okay, so we've got that? So that's the motion. So let's clarify. Who is it brought by? Mr. Marziari, Ms. Casson? It's clear? Staff have it? All right. Those in favor? Okay, it's approved. Congratulations. Thank you. And we're on to item.
Thank you very much.
Item 14 will have some residents here, I presume. Item 14 is 205 Cortleigh Boulevard. It's one variance, but it has is to construct new detached dwelling. This application was previously deferred on July 4th. There are 13 letters of objection. There are previous decisions here, And the proposed floor space index is 0.7 times the lot area. Okay, let's get to the applicant's agent. Are they on the phone? Where are they? All right, so please state your name and address.
Good afternoon, Mr. Chair, members of the committee. This is Ali Shakiri, 326 Shepherd Avenue East.
Thank you. And do you have any changes to your application?
No, sir, there is no change.
Okay. Well, go ahead. You've got 5 minutes. We got people here, right? Like there's, I don't know where they are, but yes, in person. So you've got 5 minutes. Please go ahead.
As you noted, we were here some 6 weeks ago. And my apology, I can hear an echo here. I don't know whether it's very difficult to speak. We were here 6 weeks ago. It was deferred because the updated site plan was not on the file or was not filed within the 5 days or 7 days before. But anyways, this is the one, the page on display is the proposed design, and the second page, page B, is the design that we have a building permit for. May I ask these images being zoomed in, like as a fit to page, so the panel can see them better? And if we turn pages, it would be very, very useful if we could see each page individually, because the way I see them, they're not each page. And if you can honor my 5 minutes for this. So, okay, yeah, this is the proposed design. Next page is the design that we have a building permit for. So in terms of the building mass, they are very comparable. Next page, please. And this is just highlighting the front building mass that we are reducing because of the shape of the roof. Next page. Same graph on the previous design that we have a building permit for. Next page. Yeah, that red dotted area is the building mass that we are removing from the permitted concept. Next page. Same shown on the current design. Next page. This is this house is number 239 Cortleigh Boulevard. Very comparable concept. And we go to next pages, please. Similar houses, similar concepts. If you hold this, as you can see, this concept. No, just previous page, please. Previous, not so fast. No, the page before this. This this is a comparable building mass, and as you can see, comparing to a 2-story building on the side, it looks smaller. Next page. Next page. Next. And next. If you go to page 18. Page 18, please, of my support material. The first page of the comparables. I don't see them here. If you just turn pages to where you get to the comparables. Yeah, this one. This one, if you can stop with it. This is that 239 Cortleigh Boulevard. The first precedent that I mentioned. This has been before Committee of Adjustment. Would be very helpful if we could get these zoom into page, because some of the yes, you see that 0.766 is a greater FSI approved for that house by the Committee of Adjustment, along with 10 other variances. So in total, they have 11 variances. And I have some other comparables in the area. As I mentioned, we went in length on this last time. There was a approval motion on the floor by Ms. Cassin, which I believe Mr. Allison was supporting. And I think they had to defer the case just because the site plan is not related to the variances anyways. There was not submitted on time, now we have a site plan a whole new updated drawing that is updated. It shows all the information accurately. And we also have a zoning notice that shows we have only one variance, just in case if there is any doubt on having just one variance here. And this house, comparing to what we can do as of right, is a lot smaller. I'm sure you well know that by introducing just a secondary unit in the basement, we are exempted from the calculation of the FSI. And my client needs that basement for his own family. They don't want to introduce a second unit. And I know I don't have too much time, just a few more seconds, mentioning that the support, I see some material submitted by the neighbor just today. And I just remember that my case was deferred last time because it was mentioned that I didn't submit my material on time. I want to.
Time. Thank you. Questions from the panel to the applicant? Okay, so we got residents. You'll get a chance to rebut the residents, so you'll have some opportunity there. But let's hear from the residents, starting with the first person to come to the podium, who will please state your name and address.
Thank you. Good afternoon. My name is Colin Moore, and I'm a resident at 205 Cortleigh.
Okay.
And I have a presentation that was submitted on time, but for technical reasons, it wasn't posted. But I'd kindly ask that for that to be posted with this one slide per page. Thank you.
Does staff have a presentation? Hello? Hello to staff. Are they, you got it? Okay. All right, go ahead. You've got 5 minutes.
Thank you. I would like to walk through 3 points that weren't fully discussed clearly last time. First, the applicant is suggesting that their proposal is simply about requesting a 3rd floor in return for taking some mass off the roof. I will highlight that the changes are much more extensive and are not a net benefit to the neighborhood. Second, I will demonstrate how no development in the immediate neighborhood has had an FSI this large approved, as that density was specifically deemed out of character for this block. An approval today via a multi-step process would be inconsistent with all past COA, your own planning committee, and TLAB decisions. Third, I will highlight that this house is currently listed for sale and the related implications. If you could kindly move to slide 2. As mentioned, the applicant is arguing that the proposed design has reduced the mass on the sides of the roof to the benefit of the neighborhood. They have neglected to highlight that the roof setback on the west side only lasts about 5 feet, at which time it encounters a 90-degree wall. In short, this roof line is no better and arguably worse given the west side wall. Slide 3, please. You can see what I was mentioning, but from a top view. Again, you can see the higher roof line that would now cover much of the west side. Slide 4. There are a number of other changes to the proposed design not mentioned that are detrimental to the immediate neighborhood. First, as you can see on this slide, the front porch is much larger and erodes green space and privacy. Slide 5, please. On slide 5, you can see the house from the back view. On the 3rd floor, there are now larger windows and a large balcony, which would be unprecedented for this immediate block, not to mention larger windows all across the back. These new windows are not a net benefit to the broader neighborhood, and as next-door neighbors, we personally have very serious privacy concerns. On slide 6, next slide, you can see the proposed design now from the west. There are now many more windows, including 2 on the 3rd floor, once again impacting privacy. Slide 7 highlights the underground footprint, with the new design having a much larger cold room in the front and a larger nook off the back, reducing the green space and increasing flood risk. And after the storms of the last couple weeks, this is not a minor point. On slide 8, it is important to know that the proposed design already has a much larger massing than the neighbors and is not of comparable size. For example, 209 and 215 to the west only have a FSI of 0.55 and 0.48 with 2.5 floors. The neighbor to the east is only 2 stories with an FSI of 0.41. In summary, the proposed design is not a net benefit to the neighborhood and is certainly no justification to allow a significant FSI exception. Which brings me to slide 9. At the end of the day, this is a new application to allow a major exception in FSI, so let's discuss the facts. On slide 9, I highlight the FSIs for the neighboring block of Cortleigh. As you can see, this is a unique block. Only 3 houses have an FSI greater than 0.6, and no house has an FSI greater than 0.65. It's because the lots are very big. The 0.65 house was a unique exception given its end-of-the-block location and smaller lot. Note that the comparables provided by the applicant, and you can check, didn't include a single house from this immediate block because they don't exist. On slide 10, you can skip over, but the FSIs are there, the specific FSIs are there for your reference. Kindly move to slide 11. I provided all of the recent COA and TLAB decisions for this immediate neighborhood. In every single case, after extensive study and discussion and debate, they've agreed that 0.65 or less is the appropriate density. A quote from the 2019 TLAB decision on 183 Cortleigh. By maintaining an FSI variance below 0.6, the proposal will allow a house which will have a character that can reinforce the neighborhood's surroundings. Slide 12. I highlight how a majority of the houses on this block, we're not against development, we're not emotional. We're just asking you to actively request that the unique character of this street, which is clear, be maintained via prevailing FSI limits. I sincerely ask when you reconvene that you take these voices into consideration, a number of whom are listening in as participants. Finally, slide 13 highlights how the COA, your own committee, and the TLAB have already been very clear on the appropriate FSI for this specific development. Indeed, as per the TLAB, mutually agreed by the applicant, an FSI of 0.6 was allowed only if the applicant built according to the settlement, which of course they are not doing. This is a very important point. In coming to the prior agreement, the applicant was very aware of the FSI limitations, but chose to optimize it by maxing out the length and the width with a deliberate understanding they couldn't have a third floor. If they have changed their mind and they actually want a third floor, the applicant should make offsetting adjustments to the footprint. It's just that simple and not a big ask. Finally, as I highlight on slide 14, this house is currently listed for sale. It is highly likely they're simply seeking approval to attract a higher bid. Fine, that is their right. But is this really the context we want to break all planning decisions over the last 2 decades for this block? In summary, on the last slide, there are no net benefits to the neighborhood, no precedent FSI on this street. This block has been studied extensively by everybody and agreed that's too much density.
Your time's up.
Thank you very much.
Don't leave because we do have panel members who may ask a question, and we've got one. Mr. Allison.
I heard in your testimony that you stated that the FSI is affecting the character of the neighborhood. But in the applicant's submission, they've actually put forth that the increase in FSI, as it's presented in this application, they're actually reducing the massing of the building. So I ask you, how is an increase in FSI in this case affecting the character of the neighborhood?
Absolutely. This, well, first I would just mention that all of the changes they're making in aggregate are not a net benefit. So they're just doing what they seem best. This is not a favor to the neighborhood. Number two, the house has to be looked in aggregate. They're just cherry picking one little piece. They decided, knowing the FSI limits, that they pushed out the width and the lengths to the maximum and agreed not to add a third floor. And this is a common technique used by developers to then come back later and saying, we're not making that much of a change. And finally, if this was a clean sheet of paper, would this be approved? 0.75. Nothing over 0.65 has ever been approved, including this house. So I ask you, how is that possible? I think implicitly, though, if it is improved, what you're suggesting is that FSI is not important. FSI explicitly exists for these scenarios. If someone wants to max out all other variations, this is there to constrain the density. It will make the planning process a bit of a mockery, allowing developers to set the zoning standards. It makes it a bit of a mockery of all the decisions that have been already made by this body, and it completely ignores the negotiated and executed settlement based on mutually agreed planning evidence. Finally, it goes without saying, and this was discussed last time, that this will set a precedent. It's incredible that this block, over 20 years, has been able to continuously highlight how this is a unique block. These are large lots with a density of FSI of 0.65. They can still build an enormous house by any global standard. And we're just asking them to keep to that. And that has been debated and discussed by multiple developers, multiple communities, multiple planners. And so I ask you, what is the exception to break all of that versus us turning the question to the applicant and saying, you now decide you want a third floor? Okay, where can you make adjustments on the width and the length so you can keep that prevailing density? I can't explain to you how important. There have been 13 members of our block who are just saying, look, we get it. There's going to be development. There's going to be very large houses. Can you kindly, after multiple tens and thousands of dollars, we've proven over and over again, that's the right density for this block. Can they just keep it to that? They can still build an enormous house. And thank you for allowing me to run
Sure.
off.
So just a quick follow-up. So then you accept the idea that, if they did stick within the density that you suggested is appropriate, they could still essentially formulate the same massing. But in essence, what you're sort of saying, if you're going to take advantage of, occupation of a third-story space, which would have no bearing on the massing, right, as it relates to the neighborhood of the block, then we need to re-examine or re-look at other things like building depth, setbacks, and whatnot that may have been approved with consideration in mind that there is no space on the third floor. Is that fair to say?
That is fair to say. This is just a two-step process. They're cherry picking this little piece. They could cherry pick something else and say, oh, the mass volume is hardly changing, but it's 0.85. That's exactly the point. The mass, the width and the length was approved subject to the density staying below 0.65. The applicants knew that. That's why they agreed to it. And they said, okay, but we want the largest footprint profit possible. We will not do a third floor. Okay, great. We all agreed. We mutually agreed, and we signed. Now they're coming back and saying, well, we still want that biggest footprint we could possibly do, but we'd also, and we want that third floor too. That's not a consistent planning process. That's not how this should work. This has to be looked in aggregate. And if it had been looked in aggregate, and they wanted a third floor, no problem. If they want a third floor, it's no problem. We're not being ridiculous here. We're just saying, okay, well, last time you made an exception for no third floor. Now you have to maybe bring in the length, which, by the way, their length is going way past our houses, right to the line. So, work with the prevailing neighborhood FSI is all we're asking.
Okay. Thank you.
Thank you for letting me
Don't
have the
leave.
time.
Don't leave yet. I just want to understand. You had some agreement. Are you saying there was agreement?
That's correct. Yes, there was an agreement.
Tell me a little bit about that.
Yes, there was an agreement with the owners prior to me. We just purchased this house, again, under the understanding that this house would be built with a 0.65 understanding.
Okay,
with my phone owner.
I may ask you a question to get you to the point. So who had this agreement?
The neighbor at 201 Cortleigh and the person who owned my house before. Again, we're willing to play ball. We're not being NIMBY.
I know
So we came to a
but
mutually
I wanna
agreement
understand.
with this applicant.
Just hang on.
Sorry.
Because you mentioned an agreement. I guess one of your neighbors, but you had an agreement with somebody?
No, my apologies if there's a confusion. It was the former owner of my house who had the agreement with 201 on the other side and with this applicant.
Okay.
That was approved by the T-Lab with an FSI of 0.6, only if it was built according to this, because they didn't want a third floor to sneak in.
So this was a private agreement, but it was looked at by T-Lab. So somebody is going to speak. Don't speak now. You're going to get your turn, right?
I wasn't planning to speak. I'm a solicitor. I can explain to you the whole process of the agreement.
Okay, but whose solicitor are you?
For the two speakers here.
Okay, because you get 5 minutes.
That's right.
To present. So are you going to be presenting?
The only reason I'm standing is I can explain. I was the one who went through that whole agreement, so I can explain it further to you. I won't touch on the points they're making, but if you need more details on the agreement, I'm happy to give them to you.
I think we ought to, unless, I don't want to overdo it as the chair, but I'm kind of interested in hearing what the solicitor says, unless one of my panelists thinks I'm completely, why don't you come up and just explain this? If you're his lawyer, I'll give you the time to explain the legal aspect, because it's a question. I wouldn't give you his 5 minutes, but I will answer his question.
Yeah, thank you, Mr. Chair. I won't need 5 minutes. My name is Mark Kemmer. I'm a lawyer at McMillan LLP, and you will have my letter on file, and I certainly spoke at the last hearing on this. And I just wanted to speak. What happened was previously, a couple of years ago, when the first application came before this committee, the applicant was seeking 0.65, and that FSI, and there were a number of other variances attached to that as well. That application was turned down by the Committee of Adjustment, appealed by this very same applicant to T-Lab, or a predecessor owner, but the applicant assumed the appeal at T-Lab. At T-Lab, we came forward, the two neighbors and the applicant, the present-day applicant, and using the same architect, came forward to T-Lab with a settlement. And that settlement was that the FSI would not go beyond 0.60. And the applicant presented planning evidence to the T-Lab that said that that FSI at 0.6 was appropriate. And the T-Lab decision will actually be on file with you. It was attached to my original letter. And the T-Lab member then stated that a 0.6 FSI, because part of the settlement was to take away all of the variances except for FSI and to restrict the FSI to 0.6. And the T-Lab, in its decision, agreed with the opinion evidence presented by the planning expert for the applicant to say that 0.6 was an appropriate FSI for this this thing. And the private agreement that led to the settlement, the minutes of settlement themselves were important in the sense that the applicant specifically agreed not to come before T-Lab with an application to use the third floor as habitable space. We agreed at that time that the massing could be like that. It would contain the dormer windows, but it was specifically agreed by this very same applicant that she would not use the third floor for habitable space. And that's how we restricted the FSI to 0.6.
Basically, what you're saying is we went into an agreement in good faith. It went to T-Lab. They approved this, and they're trying to do an end run around it by coming back to Committee of Adjustment to try to up it when they couldn't have done it at T-Lab because they already have a deal at T-Lab.
That's correct, and that was our concern at the time with the proposed massing, because we said they agreed specifically they would not use the third floor as habitable space,
Okay.
and that was only 2 years ago.
Okay. We got a follow-up question.
Yeah, certainly.
Follow-up question. So is my understanding then that at T-Lab, all of the variances that are on the previous notice were removed, and you guys were only dealing with FSI at T-Lab?
That's correct.
Okay.
Yeah. So it was only the one variance for 0.6 FSI. It was actually 0.599.
I just want to make sure that what's before us today isn't dependent on previous approval for other variances, because all we're looking at today is FSI.
Fair enough. And you'll remember our conversation last time. A large reason for this deferral was because they hadn't gone through a zoning review, and we were concerned because there were a number of aspects about the proposal, the building plans, that could have led to additional variances that had been previously identified. I understand they've gone through a zoning examiner now, and that's not the case, but it was 0.6 FSI, and that was the only variance. They reduced it to only the one variances last time.
Okay, thank you.
I'm just looking at the file here, so we've got, maybe I'm looking at the wrong, let me just make sure I got the right one here. We've got previous decision. We don't have a negative staff report though. Is that right? No negative staff.
I don't believe there's a negative staff report here.
Basically, you're saying that this is, okay. I don't want to put words in your mouth, so I'm not going to do that. You're a lawyer. You made your case. I asked the questions. Anybody else have questions for him? Yes, Ms.
Through you, Mr. Chair, I have a question for the first speaker.
Yeah, certainly. I only wanted to explain the process of the agreement.
That's very helpful.
Yeah.
I appreciate that. Thank you.
Hi.
Hi. You mentioned the limitations on other sites in the neighborhood of 0.6, I think, or 6.5. Were those, do you know whether those are 2-story or 3-story houses?
Most of them were 2 stories.
Yeah.
Because the developers wanted to, again, push out the width and length. And so they followed along to what they agreed to, because they preferred the mass volume, and didn't add a 3rd floor. So this applicant is doing the same, originally did the same thing, but now is trying to get the 3rd floor added, unlike the other applicants. Yeah.
Right. Okay.
And
thank you.
it would somewhat be unfair to those applicants. Thank you.
Thank you.
Okay, we've got another neighbor. So state your name, state your address, and then you got 5 minutes.
Thank you very much. My name is Alan Hutton. I'm a retired professional engineer. My wife and I reside at 203 Cortleigh Boulevard, which we acquired in 1981. Our property is immediately east of the proposed redevelopment at 205 Cortleigh Boulevard. This is my fourth appearance in the various initiatives by two different developers. I think it's the 12th set of plans that we've been asked to consider, and generally we've experienced what I would describe as scope creep, that we get some permission, we move the ball a little bit, we come back in the field, slightly different position. I've coached a lot of teams for my kids, and I don't know where those rules come from. They certainly aren't fair to the neighbors who are making a considerable effort to understand the intentions and the results of the proposed development. Our conclusion is that the proposed development is only about profit, it's not about principle, and it does nothing to benefit the many neighbors that are enjoying this immediate neighborhood, which I believe is described as block scale. Also, my final note is that the redesign has changed the streetscape considerably, with much larger dormers on the third floor than any of the previous submissions. So further evidence of what I would describe as this scope creep, which causes us, for good reason, considerable discomfort. I'd be happy to entertain any questions.
Panel? No. Nope.
Thank you very much.
Good, thank you. Further residents? Are there further residents? No, not on the phone? Not, okay. So we go back to the applicant for a rebuttal.
Well, we discussed all these issues last time, but I will answer some of them, some of the comments in the 5 minutes. First of all, a few false statements that Mr. Cameron mentioned. One of them, actually, he clearly mentioned here on the record that the previous decision of the Committee of Adjustment was appealed with the same applicant. That is not true. That was a previous applicant under the name of James Johnson. They appealed to TLAB. My client purchases this property before the TLAB hearing, so they weren't the ones appealing to the TLAB, but they inherited the lot sometime in the middle, so they didn't appeal a decision. And if you go to page number 17 of my support material, that shows the two of the neighboring houses, number 209 and 215, I guess, page 18, if you don't mind. Page 18, page 17, sorry, page 17. Those two houses, yeah, you just passed it, page 17, yes. You see number 205, which is the house under discussion, number 209, the neighbor, 3-story, and the other one, number 215, 3-story. Both of these houses are actually significantly taller than the proposal, and the roof shape is not as friendly as ours. What if somebody says that what we are doing is creating a precedent? I disagree. There are precedents of many 3-story houses, new or old, in the neighborhood. And I have submitted many photos that you can see within my support material shows that. The other false statement by our neighbor mentioned that nothing ever over 0.65 is approved. If you just turn one page more to page 18, I showed that previously. That house approved by the Committee of Adjustment, that has 0.766, which is greater than what we're asking. And there are other 10 variances approved by the committee. As far as the comparables, I personally believe that each project has to be seen based on its own merit, and I've heard that so many times around this room. What we are doing is just asking one floor space index, that's sole variance, all basically fit into the prescribed envelope of the building. We are not increasing the height. We are not asking for any wall height, any first floor height, any side yard, any length, nothing whatsoever. And it's a lot milder than, I mean, if I don't say all of the applications in the area, most of the applications in the area. And the other comments regarding the storm and privacy and these kind of things, I don't think if that has any merit, any planning merit. And I just state again that it's a very mild application, and if we just incorporate a secondary unit in the basement, then we can actually have benefit of 3 full floors, FSI of 100%, maybe actually slightly over 100% of FSI, without even coming to the community adjustment. Why we are here? Because my client wishes to use the basement. That's all, not another secondary unit in the basement. And I don't think if the neighborhood is going to benefit from that either. I would leave it to your hands, and I'm happy to answer any questions. Thank you.
Questions by the panel? I'm just going to ask the applicant. So I asked the residents about this agreement. You're saying, well, it wasn't an agreement with you. It was like previous owner. But so previous owner had an agreement, went to TLAB, got an approval. Your client then bought the property and wants this increase. Is that what's going on here?
Sorry, that's not correct.
No, the previous application by the previous, and if you can hold my time, because this is very important. If the previous time my motion approval was deferred because of a mid-motion interruption by Mr. Kramer, I don't find it fair, and now I understand that during my speech, my time, he wants to make other comments that I don't find fair. Other than that, the previous, back to answering your question, the previous owner brings a case to the Committee of Adjustment. Apparently, there have been so many other variances, and that application gets a refusal from the Committee of Adjustment. They appeal to TLAB, during which my client buys this property. They go ahead and make some sort of agreement. I mean, I haven't seen a signed copy of it anyways, but they make, I wasn't part of it, by the way. They make an agreement in the context of the TLAB that reducing that requested FSI from 0.66 to down to 0.6 and removing other variances in order to get an approval. Maybe they didn't know what they were doing or whatever. I don't know. And that agreement is not part of the TLAB. As far as I know, it's not mentioned on the notice of decision. That has been some private side agreement as far as I know. And they receive an approval from the TLAB. Later, they decided that it's not an appropriate approval for them. It's not giving them the square footage that they need for their home. And they look at the neighborhood, they see that the presence of a lot bigger houses with the third story, and all of a sudden they think, well, why can't we have that? They came to me and said, well, you know what? If we just find a way to give you additional additional floor space inside that attic, so that we are not increasing the building mass, then perhaps it's something that is reasonable. We can put forward to the Committee of Adjustment. And that's what we did, without asking for any other variance, knowing that there are still a lot of other provisions of the bylaw that they could use, such as, for example, adding the secondary unit in the basement, or even a garden suite in the backyard, and they didn't use it. So basically, they are coming fresh. They are setting that TLAB decision aside. We are not looking at it. They have had some agreements and they have gotten some approvals. They decided to start fresh, and that's why we are here with the application, just asking for the FSI. And I have submitted the supporting evidence in the neighborhood, and even on the other streets, you can see how significantly higher FSI is approved in the immediate neighborhood.
Let me ask another question. I just want to, sorry to cut you off, but I'm more concerned about this agreement. So did you go back to the residents before this application? Did you talk to them? Was there any communication with the residents about this? Hello?
Sorry, if you made a question,
Yeah,
I
my
didn't
question
hear
is
your
really,
question.
so, yeah, my question is, if you had a previous agreement, it was involving the residents, now you're making some changes, did you go and talk to the residents before you came to us?
No, I didn't have any agreement, sir. My client has had some agreement in the context of the previous TLAP. And
But why,
that
why
TLAP
wouldn't, why
decision,
wouldn't
they
you
didn't
go to the
want to.
residents and just talk to them about this, right? Like, you know that they're gonna be here.
With all due respect, sir, any discussion, that's actually that decision came from my client, and I sort of do agree that even if we come here to ask for 0.61, for example, that is not going to be well received with the neighbors, especially after what they went through for a TLAB.
Okay, let me stop again. So here's what I'm
I
going at.
have
Here's what I'm getting to, right? So I think what
Sure.
I didn't want to put words in the mouth of the lawyer, but I kind of got the sense that he was making two arguments. You're not a lawyer, are you? You're a planner.
I'm an
Architect. I don't know if you can answer these questions, but this is what I'm thinking of. Like, he's effectively saying two things, if I understand correctly, and I'm not asking him to correct me because he already had his say, but he's saying, one, it's brought in bad faith, you had an agreement. Two, it's an abusive process because you had an agreement. Like, if I look at the agreement that way, like, you had an agreement, now you're coming back to us, you had an agreement at a different level, you're coming back to us to change that agreement instead of going to the next level. Now, of course, if we refused it, then you'd have to go back to that next level if you didn't like our decision on refusal, and then you'd deal with it all again and maybe deal with the residents. But one thing is potentially an abusive process, and two, potentially that you are, prejudicing, and proceeding not in good faith because the party that you had to deal with, or who was part of that, you just bypassed them and came directly to us, and here they are all upset, and you never even talked to them. So I'm just thinking, like, I don't understand why. Why would you let somebody like me potentially think that without at least going to the residents first?
Because the application before you, sir, is too good to be true comparing to what my clients can build on this site without even seeking a variance. I'm sure any planner would agree that we can build a lot larger house even without looking at that level approval. So when we come to the committee of adjustment with an application that actually reduces the building max, not even comparing to what we have a building permit for, comparing to what we can build as of right, that is it's not only a mild application, it's actually too good to be true. That's the reality of it.
Okay, I just want to cut you off because that's okay. Let me see if anybody else here has a question. I don't know. Jordan, yes. Mr. Allison.
Thank you, Mr. Chair. Just a point of clarification. My understanding is that we had a specific massing. The massing was reduced, but I just want to pull your attention to the side west elevation. It looks, and if I'm not mistaken, as a point of clarification, it looks like there is a portion of the third floor on the west elevation that actually has increased the size of the massing in that particular area, more specifically through the extension of the side main walls directly up, whereas I think before we had a roof structure there. Just as a point of clarification, is it fair to say that, generally speaking, while you put forth that there's a reduction in the overall massing, that this section on the side elevation is actually an increase or an enlargement of the roof structure on the side?
That's correct. That one point that is in addition to the previous design, but also almost half of the back of the house. I have shown that on my graphs on page if you can display my supporting material, page 5 and page 6. If you're looking at it that way, we have removed the entire roof on the back portion of the house. Which well, which one is more important, looking at a house from the backyard or from the side? So yes, because of some design solutions to fit additional FSI into the roof cavity, we have increased portion sideways on the roof, but I still don't see those pages I'm referring to, which is very, very, very important. But for on the back side,
Labeled
would
F?
this staff be so kind of
Labeled F, right?
With,
In the supporting material?
I think E and F, yes. So
Yeah,
that's
I mean,
all,
I get-
you know, just
I
just
understand
compare
that.
that area on the discussion with what I'm just cutting off on the back side I'm reducing a lot more. Also on the eaves, I don't have the long eaves anymore. The roof lines are set back. It's a very, very sensitive. We've even provided the very realistic renderings. These houses, you know, neither the previous one nor the new one are like creating. I think is a mismatch to the neighborhood. I believe, and
I get that. I get that. Okay, I'll stop you there because I got the planning rationale. I understand the reduction. I don't think I got a full picture because, you know, in your supporting material, you've shown the side of the elevation where there's a reduction, but then I flipped to the complete opposite side, which wasn't discussed or shown, and I picked up on the fact that there's an actual enlargement to that side via a dormer. On the neighbor's side, and I'm not going to get into whether or not, you know, with respect to the Ford test, but I think it's an important point of clarification just to understand that not only myself but my colleagues understand the full scope of what is being proposed. But last question for you that I have. So to confirm. What you're presenting today is an application separate from any TLAB decision. It's coming forth with an FSI variance, but everything else you're telling me is an as of right and in compliance with the zoning bylaw. Is that fair?
Yes, that's correct. Absolutely correct.
Okay.
So, yeah, we are not looking at the TLAB anymore.
Okay. Okay. Thank you.
Because my client want to find it under it.
No further questions. Thank you.
This is a
Through you, Mr. Chair, I have a question for the applicant, and I may have asked this last time, I don't recall, but do you have what is the FSI without the third floor?
0.6. You were take 0.6.
Okay.
Basically, the footprint of this house is no different than the other one. Except the rear bump out. We discussed that before. The rear bump out is a little bit deeper, maybe like maybe a foot or 2 foot, like very, very marginally, and it could be even larger. We don't need to do that.
Thank you.
Thank you.
Anybody else want to? Okay, so I think we're done, right? We can go into committee. All right, thank you. Let's go into committee. Here we are. Oh, we've heard from all of you. You don't get another time to say anything. You probably should sit down because you can't. You can't.
Yeah, that's what happened last time.
You're done. Believe me, we're not stupid. So, okay, now we're going to go into committee. Please, committee. What do you think?
Okay, I can start us off. I mean, there's been some discussion back and forth with respect to FSI and, you know, purpose intent of FSI and what it's meant to do. In looking at the entirety of the application, you know, specifically the site plan, you know, certain things, I agree with the opposition in that, you know, they have pushed every point that they can, you know, with respect to setbacks, building length, all of that. But that they're also building a massing that's within the zoning bylaw, meaning whether they get approved today or not, they can build that same house and you wouldn't know if they got the approval or not, because it would just be a matter of the fact whether or not that third floor that space is occupied or not. I have to say, if there were other variances like depth or setback, given the FSI, I would be pretty harsh on those. But the only variance before us is for FSI, and it is essentially to create habitable space within a massing that is already an as of right. And I don't think that the impact on the neighborhood or even the immediate neighbors is adverse in any way. I don't see it, as an adverse impact. So while I do agree that the FSI as a number is high, I think the fact that the applicant has been able to put forth a building that conforms with the bylaw in every other way says to me that the FSI, albeit pushing it, is, I think, on the side of meeting the intent of the 4 tests that are before us.
Well, which test in particular? You're saying the zoning test? What's that?
With respect to the FSI, well, the first thing I look at is, like the building depth, right, in relationship to the immediate neighbors. I look at the fact that the setback is consistent all the way down. But then I go back and I say to myself, these are all as of rights. This is not it's not an issue of FSI. It's just an as of right. They've literally built the biggest house they can possibly build. If there were variances before us for building depth, setbacks, then I would go back and say, yeah, okay, you know what? Now the FSI is allowing that, but the FSI is not allowing that. That's an as of right. What the FSI would essentially allow is the use of space within that massing. So then it leads for me to think, well, then what is really the adverse impact? I just don't see there being a negative impact on the area, and I'm not convinced that this is a house or building that's going to be used differently if they have extra space. I just think the occupants are going to have more space, and you'll probably see less of them because it's a bigger house and they'll be off in some other part of it. But I was a little bothered by the enlargement of the dormer on the side, but then again, it is an as of right. I don't think it's adverse, and that in relation to the amount of reduction to the massing, so stepping in with the angular plane on the roof and removal of the roof across the back portion, I think balances any potential adverse impact from that side dormer.
So let me ask you a question, because I'm just a guy here on this panel, right? And I'm sort of asking this question because I'm a lawyer. They got lawyers, and I'm not like you. So I want to ask you, and you can answer this because this is what really would bother me, is are you saying that the intent and purpose of the zoning regulations would still be met if the committee were to allow this extra internal space, is what you're saying? Are you saying that the intent of the zoning bylaws still is not?
I believe so, because everything else is in check with the bylaw. They've created a massing that is an as of right. There's nothing, if there was any other variances, I'd be all over it with the FSI.
So you're saying, like, as far as setbacks, density, height, and all those other issues that might apply for zoning, none of those are really at issue here, and so it's meeting the intent and purpose of the zoning from your perspective, despite the fact that they had an agreement and so forth.
Yes.
And it's not just because they're sort of abusing the process by coming with another application that they couldn't have got. And you're just saying what they did was they just kind of putting this space in. Like, they could have
Yeah.
put it smaller. They didn't have to.
I mean, I got into that a little bit, but then when I hear that they've removed all the variances, because they did have a lot of variances before in the previous application, they've removed all that, and now they're just asking for FSI. And I do, you know what, I, to your point, I do think their weight should be considered, the fact that, there was an agreement. The residents, I can understand why they're upset. They went through this lengthy process. They finally put a close to it, try to move on with their lives, and then now they're back here. So I can understand the
I'm
frustration.
concerned with legal issues, right? Like you're talking about planning, but legal issues still, like abuse process, good faith and all that. But you're saying, yeah, they could have built it as a right. They could have built it smaller, they didn't have to build it that high, and then they could have just lived with it all. And you're saying, well, they could build it high, so just let them live there.
Yeah, I mean, it would be essentially blocking off the third floor space and make it uninhabitable.
Okay.
And through you, Mr. Chair, that agreement was with the previous owner, and I think, unfortunately, in this case, the property was sold. We have a new owner that we're dealing with. So I don't know that
there was something,
agreement is.
I'm not sure that was the previous owner.
Well, that's my understanding from what I've heard.
I don't know, I was looking at some of the letter. Yeah, I see, I think we got it wrong, it is the current owner. It's not, like, that's why I was asking, and then they jumped up, and then I looked at the letters, and it is the current owner. So they made this deal. So it's not like we're, and even if it were somebody else, like, then we still got to look at the overall, we still got to look at the intent and purpose, planning, all the 4 tests and stuff. But I do get concerned, and that I've talked to everybody, like I get concerned that we shouldn't be, like, this is not supposed to be a sham committee that, anybody could do anything and then just come back and incrementalizing. I don't want that to be, but I understand what Mr. Allison's saying, that, he thinks it meets the 4 tests, and therefore, so much of it was as a right. You're the experts, so you tell me. I don't get a vote unless you're tied, but I think you probably know what direction I'm headed in, but that doesn't mean that I'm right.
And I agree with Mr. Allison's comments on meeting the 4 tests. I think that in this case, unfortunately, this is sort of the new building form is 3 stories probably, and other houses in the neighborhood that come in. We're seeing it all across North York anyway. I'm sure we're seeing it across the city that there's a lot of applications for a 3rd story. And the fact that this application is meeting all other aspects of the zoning, it's really hard to say that as Mr. Allison stated, what is the impact, the negative impact on the neighborhood? Is it just the number of the FSI that you're going to say that's a negative impact? There are examples of higher FSI in the neighborhood, and I think the 0.35 that's in the zoning bylaw was imposed on this area from the old City of Toronto bylaw. I'm not sure that it's relevant. I'm not sure that the existing houses are coming in at 0.35, but I just think that from an impact point of view, and as Mr. Allison said, if there were other variances that they required, then you start looking at the cumulative effect of all these things and the impact on the neighborhood, but I don't see it in this case. And I am prepared to move a motion for approval of this application, because I do believe it meets the 4 tests. I think it is, the number doesn't appear minor just on the surface, but I think you have to look at all other aspects of the application. And I think it's desirable, and will fit in with the neighborhood.
Okay, so we got a motion.
Sure. I'm happy to second and just make a point. I think this particular file had excellent arguments on both sides, I think provided for some consideration.
Anybody else want to talk about this before I put it to the vote?
Mr. Chair, I'm trying to think about the position of the people who submitted objection. It seems they've come to an agreement, although with the previous owner.
And it's the current owner. I think it is.
These people will not be allowed an option to appeal any decision from this committee.
Yeah.
So I'm still of the opinion that we need to thoroughly review this file, this application, before making a decision.
So we've got, it looks like you're going to vote against it, so I'll turn to, you're going to vote for it. You like it. So we'll put it to a vote, but.
Yeah, put it on vote.
Yeah, put it right. I'm going to put it to a vote, but I'll just say, like, I'm sort of in line with Mr. Kabut. I know we get these, and so you know, Toronto's a dynamic place. People they build nice big homes. This home may enhance the value of the neighborhood by being the same, by looking the same as it is, but being more functional by this application. But I'm still, like, I'm sort of a stickler for process. You know, that's what I do. So I'd probably refuse it, but yeah, let's just put it to a vote. So all those in favor? Okay, and those opposed? You're abstaining. I'd be opposed to it, but not because it's bad, but just I'm stickler for good faith, abuse, and so forth. But anyway, it's approved. So congratulations to the applicant, and thank you to the residents for their presentation.
Be specific to this design, so they don't change when it's applied.
Do we have the conditions?
We do have the revised plans. We tie them, ensure that they're tied to the approval-based. Can we go back?
Okay, let's just say that it's approved.
Thank you, Ms. Casson.
Well, I get to, as a chair, it's approved condition. We didn't do it. We weren't careful enough.
Substantially in accordance
So
with the
let's just
Site plan and elevation.
site
so
plan
let
and elevation.
friendly amendment to your
Site plan and elevation drawings.
Yes, second.
to site plan and elevation drawing. How did we miss that? But we didn't now because
We were
thought-
so focused on.
Yeah, so focused on the process, which I got you into. Okay, so let's just make it clear to staff what we've approved. Does staff understand that it's tied to the site plan elevations?
Through you, Mr. Chair, yes. So substantially in accordance with the site plan and elevations submitted.
Okay, yeah, that,
Yeah.
so I think what you proved, if anything, if I could leave, is that we can get all caught up in abuse process and good faith as I do, and potentially miss like the real picture that is that, you know, we tied to the site plan, and it's probably going to be, you know, a nice house despite all that. All right, so thank you to everybody, and let's move on. We've got. Do we need a break? I don't know if we have time for a break. What's our next one? Let's go to 15. Sadly, we've got to keep going. Okay. Is this the same issue? 32, what are we on? 32, item 15, 32 Heath View. Proposal to construct new detached dwelling, integral garage and finished basement. We've got a number, at least 6 letters of objection. We've got ravine report, staff report, 2 staff reports. Got transportation report, TRCA report. We've got 6 variances. They include proposed height, proposed of the side exterior, proposed height, proposed number of stories, proposed front yard setback. And variance number 2 for the proposed building height from the rear wall. The staff have comments on that. Should modifications not be made? Committee wants variance number 2 refused. So let's deal with variance number 2. Where's our applicant? Online? Okay, put them forward, please. Hello?
Hello, how are you? This is Ruzbano Ruzipur. And
Preliminary objection to the application?
There's no notification in the public notice.
No notification in the public notice? Oh, why don't you, we'll get to that when you're going to get a chance to come up, and so you can raise it then. But well, I appreciate it, but we don't take preliminary objections. We'll take objections when you get your chance. At least I don't take the preliminary objection. You have to wait for somebody. But you
process that you just spoke about. I just want to bring it to your attention.
okay. Let's go to the applicant. Where is the applicant? They're online? Okay. Applicant, state your name, state your address. Hello?
okay, so this is Ruzbano Ruzipur, and the address is 157 Baythorn Drive, Thornhill, Ontario.
Okay.
And this is regarding 32 Heathview. Yeah.
Okay, so before you get going, do you have changes to this application? Because the staff
So
report has-
probably yes.
Hello?
Yes, I can hear you. So I do have some, so here number 2. So chap number 2, they mentioned about, I mean, I just look at the maximum height here. The maximum height should be 10 meters, no? It's not a side wall. The main wall is 7.5 meter, which is in the number 1, but item number 2, the maximum height should be 10 meters, and we actually propose for 10.30.
What? I don't know if I got this. I'm on the same one as you.
Citing an error in the public hearing notice.
Oh, there's an error.
It's number 2.
Oh, there's an error in the public hearing notice.
Yeah.
On item number 2, and you're saying the permitted maximum height is 7.5, and you're saying that's wrong?
So it should, the maximum height should be 10 meters, and we ask for 10.30.
You asked for 10.36, did you not?
Through you, Mr. Chair, the zoning waiver that was submitted by the applicant says 7.5 meters.
Zoning waiver that was submitted by the applicant says 7.5. Oh, so they put it in their, they had an error, and that error got carried through to the notice. All right. So what am I, so you're just bringing this to our attention, but let's deal with what application you have. Are you making any changes to that?
Yeah, but because I'm not sure if this public notice actually sent to the neighbors, but neighbors thought that the maximum height should be 7.5 meters here. So the maximum height is 10 meter, and actually we changed it to 10 meter point 30.
Okay, so you
Instead
were
of
asking
10
for
meter,
10.36,
36.
the staff wanted it 10.3, you've changed it to 10.3, and you're pointing out that there was an error on the notice that said 7.5 and should have said 10. Could somebody confirm that? Is that really an error to staff?
Through you, Mr. Chair, that's not for staff to determine. That would need to be the building department that would confirm that.
Well, is there anybody here that knows the answer to this? Like,
The onus is on the applicant to submit the list of variances. They submitted the variance at 7.5, so that's what's included on the notice.
Okay.
If it were to be 10, it wouldn't make much of a difference because it would be improving the situation. It wouldn't be making it worse, so notice wouldn't be required to fix that.
Right, okay, got it. All right, so that's it, you're
Okay.
making that one change on.
So anyway, I think
I've taken up a lot of time to try to understand what the application was and what your amendment was. But now, you ready to go forward with is there any other change that we need to know about, or can we just hear you? You gotta have 5 minutes, right? Like, there's no other change you're making?
yeah, just number 2. So
So
we
go
asked
ahead,
for
go ahead, we'll give you
just
5
1
minutes.
feet.
Let's start now.
We have an administrative issue because the sign was removed.
Oh, so you want me,
Proceed.
you don't
Yeah,
even know?
can
if
we ask the applicant? to
Okay,
speak to them?
okay, we'll let you come. So well, hang on a second. Okay, let's talk about that. So somewhere in here, let me see. So where is that? Do we have a letter on file about that?
36 Heath.
So this is a letter by John Petrosoniak. Is that it?
That's correct.
Preliminary objection. Okay, so let's ask the applicant to deal with that. Okay, so Mr. Applicant's agent, we've got a letter here. I haven't let him speak about it because he wants to speak about it, but he did file it, and you've had a chance to see the file, right? And he is saying that there was no notice posted within the 10 days, and so that the public has no notice of that application. What do you say about that?
Actually, it wasn't. It was the notices was there, but we realized that someone I don't know who, but because the owner's also is not living in the house, there is a tenant. but we realized that someone took so the notice was not there after. But we actually put it back, and also a couple of days ago, even we actually bring it more closer to the street and attach it to the hydro pole.
Right, but how long was it down? How long was it down for?
I'm not sure.
So
Because I was not there, so I was not tested.
You weren't there.
When did you find out that the notice was not there?
Sorry?
When did you find out that the
About couple of days ago that they actually asked me that the notice was not there, and then I just put it back, and I put it on the hydro pole to make sure everyone can see it better, and just close to the street. But because it's not a main street, then it was sorry.
But notice was mailed to all the relevant residents? Was it mailed? It's just that it wasn't posted, right? Okay. So basically you're saying notice was posted, but it was tampered with, right? Is that what you're saying?
Yeah.
And it was,
Yes.
And notice was, so notice, like, we have this letter, it said no notice was posted within 10 days. You're saying the notice was posted, you're just saying it was tampered with.
Yeah, even actually we put it earlier than that date, but
And when was it replaced? When was it
replaced?
When was it replaced?
Just a couple of days ago. I don't know. I need to double check with the office, but we receive a
I'll ask the
letter from.
resident that at some point. But notice was mailed to everybody who's within the mailing catchment for this property, right?
Yes. Yes.
And so when they took the pictures on August 7th, when did you find out that the notice wasn't there?
Just a couple of days ago, Sam asked me that it seems that the notice was not there, so I just put it back again.
Okay, like when you saw this file? Okay, when you saw that letter, did you get a call from anybody at the city? What happened? Okay, you know what? I'm prepared to let you go and make your presentation.
Okay.
You'll have 5 minutes. We'll still have to deal on the notice issue, but why don't you go and make your presentation?
Sure. Okay, so yes, the application was we actually deferred the applications for July 4th. It's because of to the respect to the consular letter, and we had a meeting with consular, and we agreed with some points, and then after also we talked with the city staff. Actually, our variances is about the height, the total height, which is actually we asked about just 1 feet more. So because the permitted total height is 10 meter, and we asked 10.30. And also the front yard, it should be 7 point something, and we asked for 6 meters. And there is a big reason for that, because we are back of them. There is a TRCA regulated area at the back we have a very, very, very sharp slope at the very back. The TRCA actually didn't give us even 1 centimeter to the back. And so the total depth of the building is about 40 feet. And also the lot coverage now is about 21%, that compared with 30% that we can go ahead. But we actually consider 21% because we can't go to the backyard. It's a very sharp slope at the back. The other neighbors better for us. If you can see the Google map, even you can see the neighbors at the right and left, the depth of those buildings even more than us. But here we have to just keep the existing rear main wall because of the deep slope at the back. So, and also there is a curve at the north side of the property, which mostly the front yard about 6.75. So more than 50% of the lot has more than 6 meter front yard actually. And in terms of the height, also we asked just for 1 feet, and we considered the proper setback. I'm not sure if you can see if there is a section view. If I send a section view in the drawings, it seems there is no section view. Okay. So the main wall height, we actually keep the main wall to 8.65, as same as the other applications, same as the neighborhood applications which were approved before. And yeah, that's all. And then we consider the third floor. The third floor also set back. We have a setback at the third, and it's kind of like the attic area. We consider the slope at the third. So why we consider that? Because the whole building is about 40 feet depth, and there is, even with the third floor, we are about 21% lot coverage. So the third floor can help this family to actually. Oh yes, this is the drawing that I'm looking for. So you can see the third floor is pretty much at the back, and the main wall is there, and we do have a slope for the third floor, and this third floor just can prepare some more rooms for this family because of the TRCA regulations at the back. You can see the very deep slope at the back. So, and I think the side yard is minor because in some places at the side yard, even we are more than 5 feet. We are close to 6 feet in the north side even. And just we asked about another feet, again, because we can't actually get that kind of lot coverage and footprint in terms of the TRCA regulations at the back. Yeah, I'm kind of
All right.
finished.
Mr. Allison, you've got a red light on your, does that mean you want to ask a question? Or
Sorry, Mr. Chair,
It's
just
like
have
me,
it.
you like to be ready. Anybody else have questions for the applicant? All right.
I have a quick question. So the applicant mentioned there is an approval with an immediate neighbor at the same side exterior main wall, correct? At 8.6.
Yes, yeah, yes.
And it hasn't built yet, right?
It was, I think,
because the street
some
looks
of those
like
at
the old
some of those at the Burbank. So I'm not sure about the heath view, but in the Burbank, also you can see that kind of main wall. But I think 8.65 main wall height is not. I saw some of those properties. I'm not sure if they build or not. So, but I saw the decision of committee on those property.
Okay, thanks.
Yeah.
Just following up with the side main wall height, you don't have any examples, any addresses, any precedent to support that variance?
We had just about I think more than 2 months ago. We asked, and 123 Burbank was approved for 8.65, and some of I'm not sure about the other property. I can double check here, but 123 Burbank, I'm pretty sure the main wall is 8.65. I can double check the rest of the. So let me see here. And I think 111 Burbank also has this kind of main wall, 8.65. So why I choose 8.65 and I checked this height with the city staff because we saw in some of those properties that which were approved within 8.65.
Okay, thanks.
All right, are we done?
You're welcome.
Let's go on to the residents then. We've got one resident. We have any other residents or just the resident who's in person? We have others? How many residents do we have?
Through the chair, we have one more online.
One more, okay, so let's take the first resident. And I know that first resident, you can come up. I know you want to talk about the preliminary issue, which I didn't give you a chance to really talk about, although I talked to the applicant about it. If you want to talk to it, I'll give you extra time to talk to your preliminary issue. Okay?
Thank you, Mr. Chair. I
So
won't
I'll
need
give
extra
you time, even though we've given him a chance, because we asked him, and I'll tell you my thought on that, but I'll let you talk about your preliminary issue as a preliminary basis to your actual presentation.
Yes.
If that's what you'd prefer. I mean, I know you preferred to raise it before, but if you would like the extra time, I'll give that to you.
It won't take long.
Okay, so state your name, state your address.
My name is John Petrosoniak. My spouse, Mary Jane Dundas, is here as well. We are the owners since 1991 of 36 Heath, 2 doors away.
Okay, so just ask the staff, don't start the time. Let him deal with his preliminary issue. I'm timing him. I'm giving him up to 5 minutes on that preliminary issue, and hopefully you don't need it on the
I
preliminary.
appreciate it. And you've raised the issue. It's a matter of process. It's not a question of not being prepared. Personally, I did get notice. Because this was an application that has come up for the second time, it was deferred a few months ago, as the applicant mentioned. And there was no notice, no public notice put up that time. I then went to the extra effort of going out as soon as I got the notice in the mail to go and check that every day. And certainly since August the 5th, until the 13th, and we did notice it went up on that hydro pole, as the applicant mentioned. So the 13th is really when the public got notice. And it's not a question of whether I have notice. I do. The other neighbors do. We've canvassed some of the other neighbors. It's a question is whether other people in the neighborhood who wouldn't be in the catchment area, whether they would have had notice. It's a matter of procedure.
I can understand, and it'll be up to the committee to decide on it, because I didn't rule it as a preliminary, and my colleague had pointed out that it should be dealt with, and I asked questions to the applicant. But my view on that is, just so that you can hear this and we can deal with it before we get into the substance. I mean, there's an affidavit, there's a photo of posting, according to the testimony of the applicant, it was tampered with, that there were certainly a number of residents that did have a chance to either see it or receive in the mail, and made their views, including you, known to. So I don't. If there is a problem, and I take it there is a technical problem, but it's de minimis. It's still that everybody kind of got a chance to. Unless I got evidence from you that I know a whole bunch of people in the neighborhood and they complained to me, or I knocked on doors and they didn't find it, unless we can prove it, I think we got to give the benefit of the doubt to the applicant on the tampering, and it wasn't the applicant who did that. And I think it would be maybe a contrary impediment to the applicant if we said, well, because somebody tampered with their notice, that they can't make an application when everybody seems to know about it. Right?
Unless I made the phone call on Monday to the city staff, this sign wouldn't have gone up at all, and it wasn't up the previous time. That's my concern.
At least you did that, but people do know. So anyway, why don't you start your 5 minutes now?
We'll
see how, if the committee wants to deal differently than my thoughts, they can always vote, on that preliminary issue and decide that they don't even want to deal with the substance. So because you've raised it. But go ahead. You've got
a few of them. There's actually I may be down to just one main objection, because I was responding to the application. The application said the maximum height was 7.5 meters. The permitted height was 7.5 meters. Therefore, the requested height would have made it 37% over the height. And of course, the only reason it's going that far is because they're asking for a third floor. We're still objecting to the third floor. There are no other third floors in the neighborhood. The comparables that he's bringing are from Burbank. That's across the ravine. Bayview Village is in a pocket. It has about 2 or 3 distinct pockets, and we're in the northern component of that. Heathview and Page and a few other streets are kind of all by themselves. Newtonbrook Creek divides Burbank from the others, and it is on a bigger street. It's a whole different neighborhood essentially on that side. So in terms of comparables, they're not really comparable. And there are other houses that have been built. We do understand that the redevelopment is happening in the neighborhood, but the main concern is that a 50% increase in the number of stories going from 2 to 3 permitted. That's a big deal. The height, obviously, assuming that the maximum height permitted is 10 meters, and again, I didn't go and check the bylaws, but I was just relying on the application. I would agree that from 10 meters up is probably not that much of a change. However, this particular property is a unique property. It's on an area where the ravine does come closer to the road. That's the way it goes. It's the smallest house on the street. They don't get to be like all the other houses that have larger lots and more room to move around on their lot and build bigger footprints. The remaining main issue then is the proposal variance number 4, which is the front yard setback. The front yard setback is pushing the house out towards the street, which is not in alignment with the other homes on the street. Now, by definition, makes it hardscape, and therefore, given as raised in one of the earlier submissions on another property, makes the issue of water runoff and other drainage issues a problem, or an additional problem. There's no need for it to be punched out to the front. It would just change the streetscape, and our concern is, because we have the next door neighbor is also planning, we're pretty sure because they've already applied once, to build their house, and we just don't want to see all the houses creeping closer and closer to the street. It just seems like one gets it, the next gets it, and then the streetscape completely changes. So that's I know other neighbors have objected. We concur with their objections as well, but if there was some way to modify the plan, it would be preferable. Definitely not going further into the street. If the maximum height is at 10 meters, it is what it is. I understand that that's just an error in the application itself, but my submissions with respect to the height then become irrelevant, or largely irrelevant. It's still over the height limit. It'd be nice if houses were built within the prescribed limits, and heights are shadowing, those kinds of issues are important to all of us. Subject to any questions that you may have, or any other members of the panel?
Questions? Okay. All right, we're good. Thank you.
Thank you, Mr. Chair.
We've got a resident on the phone. Hello, resident on the phone.
Can you hear me?
Yes, please state your name and address.
Hi, my name is Sophia Lin. I'm on 28 Heathview since 1996. I've been here 28 years.
Okay. You've got 5 minutes. Please go ahead.
Okay. This is the very first hearing I have attended. I am not familiar with the process, and only because I received the letter and has came to my attention that I didn't know that bylaw can be broken just by applications. That really shocked me as I work for the provincial government. I see a lot of wastage for resources. So I feel like this is such a waste of city resource to have the developer keep applying for variances. And I'm just in shock. And so I'm also just objecting. Oh, the developer mentioned that the lot has a very steep hill, but he failed to mention that it already has 2 levels of basement. So currently the property has 3 levels already. So it is big house, over 3,000 square foot already. I've been into the house many times. I was friends with the previous owner. It's a beautiful house. It has a huge swimming pool, which she filled. So the lot, it is steep, but it's compensated already with 2 basement story. So altogether currently it's 3 story. So if they're asking for 2 more on top, that house will be 5 stories. So as John mentioned earlier, there's no housing on our street that's 3 stories. I didn't know that the commission were approving 3 stories housing, because I just don't see why it has to be so high, especially for people that buy into the ravine lot. We value our privacy. That's why we spend extra money to buy ravine, and by going 3 story, they could really see into our backyards. So this is the main reason we object to 3 stories. As for the height, if there was a mistake, I don't know where can we go see the bylaw. I'm not familiar. I would like to also ask for a rejection for this time if possible, because my 2 other neighbors both are on vacation right now. They would like to attend the hearing, but they cannot attend personally. This is from 26, number 26, Bob and Paula Jones, and 30th, the right next door neighbor. They're both out of town. So they cannot voice their objection other than through the letter. Yeah, so as for the front, I also object to the front because as John said, the lot is a small lot. It's a steep lot, but they already compensated with 2 stories. And I object to the 3rd floor. Thank you.
Thank you. Questions for the resident? I mean, I just want to say, like, we have, so this is, you can attend remotely. Anywhere in the world that you can attend from, you can attend. So just being out of town, I don't.
Oh, one is on the cruise.
So
one is on the cruise and one is in Asia, different times.
You pay for your internet and you wake up in the middle of the night if it's that important. So I'm just like, we don't do it anyway. We don't cancel because somebody, but it's really easy to attend these. So.
Yeah, I will inform, like number 30, 29 and 30, no, 29 and 31. They both are very senior people. They're not good with internet. So that means we will have to bring them in personally for them to file. They don't even own a or to write. They're all the seniors in their late 70s and not 80s. So
we don't have a
hard
lot of
for
time,
them to.
You know, there's fairness to both people, right? You know, we try to do
Right.
everything like to make it accessible, but you've also got I'm not part of this, but you got an applicant who wants to do something. They get a chance to. You can't, if you keep on adjourning just because somebody has this issue or that issue, like it's pretty accessible. So and anyway, I just wanted to mention that. Let's move on.
Thanks.
Okay. No question. So let's move on to that's it, right? We go back to the applicant. So you get a chance to rebut the residents. Try to focus on that, please. You'll have up to 5 minutes, but hopefully you don't need that.
Okay, thank you so much. If you double check again the Google map, at least you can go to the Google map, you can see both property, even number 36 and 26, even also the number 26 is pretty much, they have a very, one of the smallest footprint at the street is 32, even you can see at the Google map. Because again, there is a very sharp slope at the back. And because of that, we consider a little bit more frontage and also the 3rd floor. These are the reasons. Even number 26, the depth of the lot is around 1.5 times bigger than us, roughly. And also we consider one basement here. And for the third floor also, in terms of the height on the third floor, even if you go to the side section, you can see that even the total height we consider that the people can see from the street, even less than any other new constructions, classical or contemporary houses, because at the very front you can see kind of two-story house, and a little bit back you can see the third floor, which is not that kind of it's not visible even from the street, but we actually didn't consider the very high building. So it's the total height is about 10 meter and 30 centimeter, which we ask about just 1 feet more. And what we can do for the third floor, if we can, I think probably in the drawing we didn't consider even any windows to the side. So we can not to have any windows to the side and just windows at the rear
stop you
yard.
for a second. I don't think this is this answering the residents' issues? I don't think they are. So, the widows are? Okay, so keep going.
Yeah, because the objection is about the third floor, the height. They had objections about all the variances anyway. So I just want to explain a little bit more regarding that. So even the third floor, we actually didn't consider any side windows, and we do have windows just at the rear yard. And the front yard also, again, the most of the front yard has more than 6.5 meter setback. Just at the very south side, we have 6 meter. And I think these are the answers, yeah.
Maybe I just got a question on this, the error in the notice, right? So you said that we're kind of accepting it. Do you have any evidence to support that this was an error? You know, can you quote us like from the bylaw or anything like that so that we know that we've got it right when you say it's an error? Because that's really your obligation.
Through you, Mr. Chair, we're going to change the notice so that it says 10 meters as the bylaw. So if that is incorrect, the applicant would have to come back.
Can I make a comment?
Okay.
Can I make a comment?
Yeah.
I know it's not our job to check the bylaw, but I just check online and it's 10 meter high, 2 stories,
Okay.
so I can confirm that.
So that's fine. Based on that, I don't think I've got any further questions. Anybody else have questions? So
I
let's
have a
go
question from
from
the
the
applicant, actually. So what is the allowable length? You are proposing 40 feet, which is about 12 meter. What is the as of right? Is this 17?
I think based on the lot size, and it should be around 19 meters, but we
19
consider
meter is
12
depth.
meters.
No, I'm asking about
The-
length.
Yeah, the length. The length could be, I think, 18, if I'm not mistaken, 18 or 19, I think.
And the reason that you are at 12 is that the reason for my question is actually I have concern about the front yard setback because the building is pushed forward a lot. It's not aligned with the two immediate neighbors, and I think it's going to affect the streetscape. I just want to understand clearly what is the reason for that. Do you have a limit to push the building further back other than TRCA or?
No, the TRCA, it's a huge, so sometimes we can get 1 meter or 2 meters, something from TRCA to go to the, if you can see the site plan, you can see how huge the backyard. And even we couldn't even use 1 centimeter at the backyard. The TRCA told us we can't move even 1 centimeter the rear main wall at the back. and there is a huge backyard compared with the whole building that you can see. Even if you can see number 34 at the north and I'm not sure about number 30, I think at the south, all depths and approachments of those buildings is further than us. But in terms of the character of the lot, if we can't, because it's impossible to consider any architectural plans in the efficient way with 35 feet or 30 feet depth. The 30 feet depth or 35 depth, it's very minimum to design something. Yeah. Then that's why, and also there is a cost for my client to go again to the third floor, but because the lot area is about 9,000 square feet is the lot area, but we consider just 21% footprint. And then again, at the north side of the site plan, you can see, if you go to the number, you can see 6.75 setback, not 6 meter. The very south side of the driveway is 6 meter, but there is a curve at the street here that we have 6.75.
Okay, thanks.
If you can zoom in, yeah.
We have other questions on this? I also have this concern about the front yard setback. And I don't know, do we have, how is this, I don't know if I saw the entire streetscape on this, but I am concerned about the creep on the, because once one gets it, everybody gets it. And I can see like the topography on this lot, when I look at it, I can see why they're kind of limited on what they can do to go in the backyard. But how far, like, I don't know. Let's go into committee then. I don't really know what I can ask them on it. Let's go into committee and leave it to you. Mr. Allison, do you have something you want to say on this? I think you do.
A few comments.
Yeah.
I share the concern with respect to the front yard setback. It was also brought up by the neighbor. We've had a couple of these applications where you're dealing with a ravine at the back, and I do understand the limitations of that. But I also, the neighbor said, you have when you inherit or you purchase or you acquire a lot, you have to take into account the built natural form. Some lots have extensive ravines, and they could be 300-400 feet deep lots, but you may only be able to build on the first 10 or 20% of those lots. So that I think that is a limitation of the lot that just to a certain extent needs to be accepted. That you just can't build a massive house or on this lot, or I should say the same size house on this lot that you may on another lot that doesn't have the ravine in the backyard. I think there is some give with respect to the front yard setback, but the 8.6, apologize here, the 6 meter setback I just don't think is enough. I think 1.75 meter setback is too much. Also because they are using that setback for an entire front main wall, whereas the averaging of the neighboring properties is a result of lower scale bump outs. So I think, we're not talking about just a garage coming out here into the setback. We're talking about the whole front main wall of the building. So I've got some concern with that. I think that in I'll jump to dealing with variance number 3 with respect to the stories. I think this area in particular is very sensitive to, you know, yeah, a three-story building is going to stand out in this neighborhood, and I think the neighbors did a good job of, you know, raising those concerns. Not to say that I don't think that the application could support a third story. I think they did a really good job of stepping it back off of the front main wall, and even going so far as to provide an angular plane drawing from 6 individuals standing at 6 feet across the adjacent street to show that the third story is not visible. So I'm actually supportive of that variance, but then I have to, you know, the other variances for height, like the 10.36 meter and the side main wall height, those things for me become problematic. Because if you are putting in a third story, I need to know that the third story is not driving up the height beyond what would otherwise be, you know, requested. So, you know, it drives a fine line where you start redesigning somebody's project, right? Yeah, those are my comments. Curious to see this north and south side yard setbacks. I'm okay with, but I think the side main wall height could do for reduction, and I don't think that the overall height is necessary. If you look at the finished floor heights on between the levels, there's more than enough space to accommodate the third story without, you know, making this massing any bigger.
Anybody else? People are fatigued. We do such a good job. We are so thorough that we are all worn out. Do you want to put a motion, Mr. Allison?
I mean, my only concern is just given the delicate nature of the third story addition, I would like to tie it to elevation drawings and even a plan drawing of the third floor, just to ensure that that step back is maintained. But my fear is that in amending the variance for the side main wall, I would be creating an issue. So I wonder if we could add a condition in to deal with that by stating that there's an angular plane drawing. So a condition to the submission of an angular plane drawing that demonstrates the third story is not visible from 6 feet above the sidewalk on the opposite side of the street.
Through you, Mr. Chair, I don't think we could accept that because who would be signing off on that drawing?
Zoning. I mean, it's a standard drawing used in heritage planning. They've gone and submitted it for different reasons, that type of drawing, but I wonder if there's any way to, or even perhaps to tie the variance for the third story, variance number 3, to limit it to the extents on the third floor plan drawing. Third floor plan, yeah. Floor plan, yeah.
So is that a motion?
But don't quite know if I can. It's
Yeah.
one of those where I bring a motion, but I'm not sure it's gonna.
You want to bring a motion to refuse it then?
We might have to. Yeah.
Well, why don't you do that, and then at least
Okay.
you can see if anybody wants to second it, because I'd like to move this forward.
Yeah,
And take
okay.
a break, because I can see we're running out of energy.
Yeah, fair enough.
You don't have to. I don't have to force you. Somebody else might want to bring a motion.
Yeah,
I get that feeling that you're sort of inching towards that, so just bring it and let's see what happens.
Yeah, I mean, I would like to bring a motion, but I don't know that I can bring
Okay,
a
so
modified motion.
Let's instead
Given
of
the
putting
amount
you-
of changes.
Putting you on the spot. Got anybody else that wants to bring a motion? I'll go back to you, Mr. Allison. I think, why don't you bring your motion to refuse it, because nobody wants to do anything, so at least we'll have a motion, and then we can see where we're gonna go.
Yeah, I unfortunately, I have to bring a motion to refuse the application.
Okay, so we got a motion to refuse the application. We got a seconder for that motion. I'm looking at you, Esther.
I second that. I share the same concern with Mr. Allison. I have concern with the front yard setback. I'm not quite convinced that this 6 meter setback proposed is appropriate for this property, and also the combination of third story and the sidewall height. I think these are problems for me, so I second that.
Okay, so we've got a motion on the floor to refuse it. Do you have anybody that wants to talk about it? I see a lot of silent people, so let's put it to a vote. All those in favor of the motion to refuse, please raise your hands. And it is carried to refuse it. So thank you to the residents, thank you to the applicant, and let's take a 10-minute break. All right, thank you.
Here's just about 30. Anyway, so I just want to understand this. You say you're going to accept the law. You mean it says that? You mean it says that? But it didn't get to until the second. You see, they weren't accepting our submissions, and it was all we needed, because it wasn't mailed in. We didn't get it on the 12th. So we have 20 days from
sure when she got the letter. Because she had a flood in the basement. She had to be flew around with the insurance company. So she's gonna check and see when she emailed me. That's the first time she. Yeah. He's like, no, we talked about this. And he said, I could get it. So that's what I'm talking about. Maybe you could put, what he said, discussions. With the school. Just oh, no, I'm just saying. Since she sent it, she's Sandra said she sent it to you. I spoke to her on the 31st. I said, if she's in, I said to her, if you're in, I'll get her. Who's are you? What I'm gonna talk about is, I was supposed to put it on, it wasn't, maybe they don't have to do it.
Okay, hi everyone. We are back. Okay, let's deal with item number 16. (153) Donley Drive, 4 variances, proposal to legalize and maintain front yard parking. Application was deferred on July 4th to address revised zoning notice. There's a letter of objection, there's a staff report, there's a transportation report, a few transportation reports. Of the 4 variances, they deal with front yard landscaping, parking spot in the front yard, parking space width and length. All right, there's nobody opposed to this. There is an applicant somewhere. Where are they?
Good afternoon, Mr. Chair. Jay Smith, agent for the application.
And your address?
2814 Hollington Crescent, Mississauga.
Thank you. Any changes to your application?
No, Mr. Chair.
Looking at my panel members, anything anybody want to talk about it? No. It's 16. Maybe we could make a short presentation. There might be some interest in that.
Absolutely, Mr. Chair. The owners purchased the home in 2020. About a year or two later, they got a zoning bylaw officer come by and they got a notice for front yard parking. They had not realized when they purchased the home with this existing condition that this did not comply. So we are here to legalize the existing front parking. We did look at converting this to a parking pad. The thing we found was that we were going to really negatively impact the front yard landscaping if we changed it to comply with the front parking pad. The front walkway is integrated into the driveway. Vehicle parking is currently outside of the right-of-way. Given the existing condition at 151 completely matches 153, as well as the other homes that they sent in as part of my cover letter. Front yard parking is prevalent on the street, and I'd be happy to answer any questions that you might have.
Do we have questions? You do. Go ahead.
Just a brief question. In its current form, where the hardscaping is, it's not able to accommodate a front yard parking pad. You're saying that you would have to remove some of the soft landscaping I'm assuming to fit the minimum required dimensions for that?
That is correct. Through you, Mr. Chair, we would have to bring the parking pad closer to the road. We would have to remove a significant amount of the existing soft landscaping in order to meet the 2.6 meter by 5.6 meter minimum requirement of the parking pad. We would then also have to have a front yard approach to the stairs. So right now, the hardscape is kind of doing double duty with the walkway and driveway. We'd have to basically create both if we had to do it as a legal parking pad.
Okay, and are there any examples on the street? I know you're talking about the adjacent neighbor, but I just want to make sure that we're distinguishing between a parking pad, a driveway, a walkway. It's, because if I didn't see a car park there, I'd look at this condition and I would just assume it was a walkway up to the front door, right?
Absolutely. 147 and 149 have significant front yard parking, as well as number 158 in my cover letter. They have most of the front yard paved, right up to their front walkway, as well as the mutual right of way. Then we have 171 where they have a full parking space, as well as private approach, taking up a significant portion of their front yard. 177 would be a similar condition. They have a private approach as well as almost 2 parking spaces in the front yard, and those are again all in the cover letter.
Okay. And lastly, there was a letter of opposition. I'm just wondering if you had a chance to read it, and if so, if there's anything you'd like to address in that letter.
I did read the letter from Mr. Price. It seemed like a generalized letter on parking pads. I did not see that Mr. Price was in the immediate area, so I'm not sure what property he's from. I do understand the frustration with people with parking pads and licensing. In this case, I think an actual legal parking pad compared to a parking space would have a negative impact on the immediate area and increase the hardscaping. So we thought that bringing this to committee as a front yard parking and not a parking pad would help to minimize that soft or that hard landscape area.
Okay. And lastly, is a front yard parking pad, do you know if it's an as of right on the property?
Yeah, it would be as of right a front yard parking pad. There are a number of them on the street already at multiple locations. So it is a common situation on that street.
Okay, thanks. No more questions.
I have a follow-up question to Mr. Allison. So if the front yard parking pad is permitted as of right, but would that not create a landscaping issue on the front yard?
It would. We would be allowed the front yard parking space, but then yes, we would have a variance for the landscape, and as we do now. But it would be significantly more hard landscaping to soft landscaping, and our percentage, which we almost comply with, I think we're 47.3 instead of 50%. It would be in the 20% range, 25% range if we did the front yard parking pad. As far as transportation, we would be entitled to a front yard parking pad.
Thank you.
All right, so we've got our presentation. We can go into committee, right? Let's go. We have a motion or discussion, Ms. Casson?
I'll start the conversation. I don't have a problem with this application. I think, because it's existing, it reflects the side neighbor. It's a mutual driveway situation, so there isn't the option like some of the houses have their own private driveway on their lot, but in this case, they don't have it. So I don't really see a problem with it. I think it probably is more important to maintain the front yard landscaping in this case and permit what is existing. I might have a different opinion if this was a new application, but because it's an existing situation, I don't have a problem. And I'm happy to move a motion for approval, but I'll hold until everybody has a chance to speak if they wish.
Well, why don't we take your motion?
Okay.
Yeah, let's take
So I will move a motion to approve this application with no conditions.
Okay, so we've got a seconder, Mr. Margiari. Anybody have any interest in discussing this, or can we put it to a vote? Okay, let's vote. Let's vote on it. Everybody in favor? Okay.
One opposed.
One opposed. We've got 3 in favor, 1 opposed, and I don't have to vote, so I'm not going to. All right. Let's go on to the next one, which is what's that? 17. All over the place. 17. 17 is 1885 Leslie to include outdoor patio area with banquet hall. It's proposed outdoor patio in conjunction with existing banquet hall. It's not a permitted use in this zone, so that's for a zoning variance. We've got an arborist report. We got 2 arborist reports. We've got 3 letters of objection. We've got a letter of support. Where is our, we got an applicant somewhere? On the phone? Please come forward, applicant.
Can you hear me?
Yes, state your name, state your address.
My name is Walter Vaz from 1885 to 1933 Leslie Street.
Thank you. Any changes to this application before we get going?
No.
All right. So there's residents here who want to speak, so why don't you go and have your 5 minutes, starting now, please.
Sure. So, wait 1 second. So York Mills Gallery is a licensed banquet hall that is one tenant of a complex located at 1895 to 1933 Leslie Street. As you may or may not know, the City of Toronto, the use of a patio is automatically assigned to a restaurant license holder, but is not an accessory use to a banquet hall. We are applying for a minor variance to allow us to perform religious ceremonies in conjunction with the receptions utilized within our licensed banquet hall. It should be noted that we are not requesting a minor variance to allow full patio or, as the Toronto City calls, cafe license, or any type of restaurant operations or outside servicing. Not requesting any food services to be allowed, only that ceremonies are allowed to congregate and people be allowed to perform religious ceremonies. The space that we are requesting is a communal park setting that was built through a landscaping permit back in 2019. We will note that in 2018, we did apply for and were refused for a new entrance, a large-scale patio cafe operation. We note that we abided by this decision. We heard the neighbors' objections at that point in time, and we did not exercise our right to appeal that decision at that time. Today, during COVID and afterwards, and we've received many requests to hold religious ceremonies outdoors, as this is a custom for many new immigrants now residing in our city. This is also a growing outcome from the COVID pandemic. People's reluctance still to be in close proximity to others when they feel much more comfortable outdoors. The minor variance we're requesting is that ceremonies be allowed in the area located to the southwest portion of the property. The area is bound by some fencing and a number of trees and hedges. The only residential area is further to the west across a 4-lane roadway of Leslie Street and butts to the backyards of the first row of houses on Leslie Street. The objection letters received by the council for this proposal seem to have not taken into account the actual request of this variance. The scope of what is being asked for today. Letters talk about the continued noise until 2 and 3 in the morning, talk about music being played at all hours of the day. I believe that they cookie cutter copied the same complaint letters received in 2018-19 against the full cafe operation application. The ceremonies being proposed through this variance are generally conducted between the hours of 11 a.m. and 8 p.m., are less than 45 minutes in length. They are sometimes accompanied by light music as a bride or partners walk down the aisle prior to a ceremony. And once concluded, these groups will be directed into the banquet halls to further continue their reception within the licensed hall. Again, we're not proposing any food services to be conducted outdoors. We are not adding any capacity to our operations. We are not adding any parking or anything like that. Patrons utilizing the outdoor ceremony option will be the same patrons utilizing the banquet hall. We believe that this use should be automatically assigned with a banquet facility, but unfortunately the bylaw is not written that way. We believe that the use is acceptable for the property and the businesses associated within that property, as good planning and needs for the city have diversified over the last number of years. The minor variance does not propose any negative hardships on either the surrounding businesses and or the adjacent neighborhood. I think it's noteworthy to point out that several other outdoor patios currently exist and are in operation along the same stretch of roadway as ours, namely being the Keg Restaurant immediately to the north, the first plaza to the south of us 30 feet away, a cafe, and the second plaza to the south of us, the Goose and Firkin, along with others in the Longo's Plaza. These are all allowed to operate at all times with music, services, etc., but would of course abide by city noise bylaws currently in place. We'll note that York Mills Gallery as an operator has never received any tickets for noise or operating outside of our current zoning uses. We do find it interesting that the complainants are all located within 10 minutes walking distance. Absolutely no noise from ceremonies could possibly be heard from religious ceremonies. As such, we urge the committee to allow the use and approve the minor variance requested. Thank you very much.
All right, thank you. Questions to the applicant from panel members? Yes, Mr. Allison.
Is there any amplified sound on the in that area for the ceremony?
There's nothing permanent. There's nothing permanent. We would anticipate slight amplified like procession music for ceremonies, and that would be on a temporary basis coming in strictly for the duration of the ceremony.
Okay, and you guys, again, haven't received any noise violations or complaints in previous years in this space?
We have received none since operation from 2014.
Okay, thank you. No more questions.
Others? All right. Residents in person? Are there residents in person? No? Yes. Yes, come on. We have 2 residents in person, right? At different addresses. All right, go ahead. Please state your name and address.
Michael Boltman, a resident of the York Mills Leslie area.
State your exact address now. Please.
Address 174 Woodsworth Road, Toronto.
Okay, you'll have 5 minutes. Go ahead.
I could probably speak for about an hour on what this gentleman just said. Some of it, a lot of it is untrue. We have a lot of the residents who live directly across the road, and the noise levels at night were very, very loud, to a point where I came over to her house and saw it firsthand. I've called 311 numerous times. Bylaw officer did not come out. They do not work weekends. That's their excuse. This gentleman was refused an application back in 2018 because he's not a restaurant. He's a banquet hall. He then proceeded to beautify the property and use an end run around this, and he put down concrete pads, or 2x2 pads of concrete for about 30 feet by 40 feet, and put up a big hedge behind it facing Leslie Street. Then the music and procession started. Sundays, maybe Thursday nights, late Saturday nights, they would have indoor functions and it would all come outside. One of the previous Committee of Adjustment members in 2018 was a lady, and unbeknownst to anybody, she showed up there the Friday night before the COA meeting, whichever day that was during the week back in 2018. And to her surprise, she said, I couldn't believe the amount of people spewing out of that building onto the back patio, which was illegal at the time, and the noise, and they were all carrying drinks. She says, were they alcohol? She has no idea. But they were partying, and they were going outside of that area, walking toward Leslie Street. Okay? So we have problems with this. We have noise problems. We have bylaw problems. They didn't uphold the bylaw decision that was made back in 2018 saying you cannot do anything outside, period, end of story. Well, that's not good enough for them. So this is their second attempt to come around and do the same thing. They held religious ceremonies back in 2018, 19, I'm not sure for 20, but the last few years they have. They built a structure on the same property, which they call the patio, which is illegal to begin with. And the structure is humongous. holding hundreds of, well, let's say 100 people anyway, okay? Then they would tear it down, and they put out loudspeakers. And the residents were complaining to the board, which I used to be a member of. And I left the board for one reason only, because they continued to break the bylaw, and because 311, the bylaw officers, refused to do anything. Well, we don't have anybody on the weekends. Well, that's not my problem. Your problem is to be there. That's what I told them. Now, I have a letter here from Jay Robinson. Unfortunately, Jay's not with us anymore. Otherwise, she'd be sitting right beside us. And I'll just read you briefly what it says. It's dated June 28, 2018, to Mr. Daniel Tennessee, Manager and Deputy Secretary Treasurer of North York Committee of Adjustment. I'm writing to the Committee of Adjustment to advise the Chair and members that I am opposed to this application for the address above. As described in the many letters and objections submitted by the committee, an outdoor patio would have significant adverse impacts on the surrounding neighborhood. I have been contacted by several residents concerned about the potential noise and traffic-related issues associated with the construction of an outdoor patio. She goes on and talks about that further on. I don't want to get too far into that letter. We also have a letter from a past president, Alex Greco, and it was CC'd to John Tory. We sat and had a meeting with John Tory on the phone. I wasn't going to say anything, I was just to listen in, but after I heard some of the untruths that was being said on the phone, I interrupted and said, I'm sorry, I have to say this. Now, he said to me on the phone and to the other members, he was never present at any of these functions on the patio. I says, as an owner, how could you not be there? Well, I had a manager. I said, if I had a manager who allowed this and I didn't know about it, that manager would have been fired a long time ago. He didn't say anything. So we hear a lot of falsehoods from this company that just irritate the hell out of us, because we like people who follow laws, we like people who follow bylaws. That's where they were made. If he would have been a great citizen and not had any parties out there whatsoever and came back now asking to do what he wants to do, we probably would consider it. But we're not considering it under the conditions that this man has proved himself to be.
You got your 5 minutes are up now. So
Thank you very much. If you
just stay at the podium in case we've got questions. Are there questions for you? Yeah, there is a question for you.
Is there, are there any mitigating things that you can like suggest that, you know, that could permit this use, but also not, you know, have us run into noise issues that you've experienced? Are there certain things that you've asked for, whether, you know, it be maintained a certain decibel, or that the patio only be used up until perhaps a certain time?
Well, first of all, he's in violation of the bylaw. They said nothing outside. Secondly, he is not a restaurant, he's a banquet hall. So the first thing he would have to do is be rezoned or get acceptance from the COA to approve to put a patio out there and do what he wants to do. Controlling the noise, you know what I mean? If it's almost impossible to control the noise. I've been sitting in Sandra's house directly across from this, like strictly right across the lane. I'm looking to you. Windows closed. I've heard the noise inside her house at 5, 6 o'clock in the afternoon. And this goes on for hours and hours and hours. He swears that he never had anything out there. He used to swear that he had nothing out there. I'm sorry, it's wrong. Completely wrong. And the restaurants, the Keg has a small area, a patio, maybe 25, 30 feet long by maybe 20 feet deep. That's right at the corner of Bannatyne and Leslie. I drive out there every day, maybe 10 times a day. I don't hear anything. Right. Absolutely nothing. The Goose and the Firkin down the street on the other side of him to the south. Maybe once a year you'll hear something, they'll have a big party. That's it. You'll hear nothing. Yep. Okay? He is closer to the road than they are with this new patio. This patio should be torn down and dismissed. I mentioned to him in 2018, if you really want to have a banquet hall, you really want to party and party loud, go up to Jane and number 7. They're loaded with nothing but banquet halls, and the area is zoned for such. It's called ICI, Institutional, Commercial, industrial.
I know. I worked on the master plan for Jane and 7,
Yeah,
so
so
I'm
you
very familiar
understand.
with the area. But is the issue then with the noise a result of amplified sound, number of people, or
Both.
Okay.
Both. More so, well, I can't say one or the other because people make noise. And when you're playing music and you're celebrating, you're having a good time, what happens? The music goes up and everybody starts yelling and screaming. You know, they're happy people. I don't want to take that away from them, but that's not the place to have it. It's in a residential area.
Okay. Okay, thank you.
Thank you. Any other questions?
No, you're good to go.
Thank you very much.
Got another resident, please? Do we have another? Yes. So please state your name, address.
I'm Dr. Tom Weinberger. I'm a retired family physician, and I was the past president, I was the president rather of the York Mills Neighbors Association, which objected to this process in 2018. That organization was amalgamated to form the York Mills Neighbors Association, on which I was vice president until I stepped down a couple of years ago. And I live at 73 Farmstead Road, which is within a block of the Sandra Serafini, who put in a letter of objection that was signed by myself, Mr. Boltman, and the president of the York Mills Neighbors Association now, Paul Grimes.
Okay.
So should I start? I partially have a notice of objection, actually, because the notification did not seem to get out in time. And myself and Michael Boltman were only advised of this process, I think, on the 6th of August. And what I would ask the committee to consider is to delay your decision based on looking back on the previous history of the York Mills Gallery's performance in the past and the objections that that were presented, the notes that the late Councillor Jay Robinson, who unfortunately is no longer with us, has in her office, as well as their documentation of emails back and forth from myself, Jay Robinson, and other officers of the city who had issues with the noise complaints, as well as some other issues related, some violations that they did not clarify. They said we would have to go through the process of trying to get that information legally. The original decision, as you know, was unanimous by the CA to deny them the use of an outdoor patio. As Mr. Boltman already has pointed out, that they built this beautification project, which in fact they have used blatantly without having permission, specifically denied being allowed having outdoor parties on this patio. They've had numerous complaints, as already pointed out, and now they're asking that that they will only hold religious functions on outdoors. They have illegally and blatantly flaunted the law that was passed forward by this committee. They have held outdoor functions blatantly opposed, in opposition to the original decision by this committee. And they would have you believe now that all of a sudden they would comply completely with a very short ceremonies with minimal noise. Unfortunately, we weren't allowed to submit the email threads that we brought and pictures that we have that were posted on their website of functions that they held outside illegally. And now they're saying to us, trust us, we've reformed, we're going to have very short ceremonies outside and no issues for the neighborhood to deal with. We brought those printed out material with us, but apparently we're not allowed to submit it to you because they weren't, we didn't have enough time and didn't know that we had to submit them to you. So again, I would ask that If you are unable to make a decision at this time, or would like to investigate the information that already exists on several platforms that we're allowed to do so, the committee members could go on the YMG's website and see that they have posted pictures of them having outdoor activities while they were illegally doing so. You may have to search the website because they've taken off the advertisements that they've had that they are an outdoor facility as well as an indoor facility. We have those pictures. And lastly, this is not a very smart. What I'd like to know is, how many times is a business allowed to come forward with effectively the same request with identical submissions when the laws haven't changed? Does the COA consult the previous submissions and try to investigate to see if, in fact, the business applying for this has actually had complaints against them that did not get to the level of being formal, because there are no supervisors? You can call the supervisors. There's nobody available on the weekend. There's no point in them showing up during a weekday when there's nobody there. What is the point of having rules and regulations when those laws aren't enforced? It becomes a joke where the citizens
your
and people that are
now.
being impacted
So we'll
are
have to
ignored.
stop
Thank you.
Thank you. Panel members, questions of the resident? I see none. All right, thanks. Let's go back to the app. There's no more. You can have a seat. No more.
Okay.
Thank you. Okay, applicant. Mr. Applicant, agent.
Yes.
Go ahead. You have up to 5 minutes to rebut anything said by the resident.
Thank you very much. So I think firstly, as acknowledged in our submission, this is not owned property by us. The beautification process was done in consultation with the landlord. All the necessary permits were put in place to remove trees, injure trees, to make a communal space for the entire building. It does have the ability to hold ceremonies for us, and hence why we're coming to the committee. I think it's very important to distinguish the gentleman has said that we've come back a second time with the same application. This is in no way the same application. Our first application was to build a permanent cafe patio with walls, entrances, setbacks, fire, water, gas, utilities, service, alcohol licenses, music, everything the same that exists at the keg to the north of us. We abandoned that process, and we actually did listen to the neighbors. But the neighbors don't come with any solution whatsoever. As one of your colleagues has mentioned, perhaps it's a decibel level, which we don't believe is necessary, but if it was imposed, we would object, we would agree to it. All of the submission that we have today is simply to allow religious ceremonies to take place for a period of time of a half an hour, 45 minutes, or an hour. It's required by the law to have this from bylaw so that they know people will congregate there, and there's a safe exit, which would be across all the grass and the interlock stone that is there. I can tell you that bylaw has in fact been out many occasions. When the neighbor talks about parties, we have to remember that we have gone through COVID at this property, and at one point throughout the COVID process, we were allowed to erect a tent. We were allowed to do outdoor parties of certain sizes and volumes, all within the COVID guidelines. I will reiterate again that despite maybe there's complaints from the neighbors, we have no ticket, we have nothing from the city on noise and or a bylaw infraction.
All right, thank you. Members,
thank you.
Questions of the applicant? I see none. All right. So now we're into committee. You may as well sit down because we can't hear you anymore. But we're in committee. And committee members, any discussion on this? Any debate on this? Anybody want to start talking about it? Anybody want to bring a motion on it? Mr. Allison.
I just question whether or not there's a way we can impose some limitations on time of use. Because I take the testimony of the residents that showed up today, as you know, the fact that they've had issues with this in the past. There is clearly an issue with respect to these two zones abutting each other. Initially, when I had looked at the site, I thought, you know, there's a good spatial separation between the backyards of the residential zone and then the commercial zone. But I think given the type of use, and I you know, in looking at the variance itself, right, like I could see why a restaurant use would be permitted, and why perhaps a banquet hall, a patio that's in conjunction with a bank hall may not. Both of those uses result in different, you know, effects, and I am concerned that the use of this is not compatible with the proximity of the residential zone. Now, that's not to say that it can be, but I think there has to be some limitations on how and when this space can be used. And I certainly don't think sort of telling the residents in our zone just to call 311 is kind of really fair. I think it's just kind of pushing the burden on to somebody else to deal with. So those are my thoughts. Yeah. Those are my thoughts.
Yes, further to what my colleague just said, if you go to maybe staff could put up the letter of support that came in from the applicant. I think it was just listed as a letter of support. It's got a list of what limitations they're willing to accept. I mean, I have a problem with this application because it's really not an outdoor patio. An outdoor patio is a seating for restaurant facility in the zoning bylaw. So it's really to use an outside area for what's permitted inside. That's really what this application's about. But he is, I mean, for better or for worse, zoning defined it this way. So, but if you look at the list of things, they're saying that they're willing to accept these limitations: ceremonies between 11 a.m. and 7 p.m., no food or beverage service, temporary setup. I think those are the main things, and to just only permit ceremonies outside.
Yeah. I mean, let's just call it what it is. We hear religious ceremonies, and it actually confused me because I'm thinking, what religious ceremonies going on at 9 o'clock at night that's creating noise? I mean, they're weddings. They're hosting weddings and other, you know, events.
Right.
People are excited, and I can see why the neighbors don't want to interject. Those are, you know, special time for those people. But we do have to ensure that this use is compatible with the adjacent zone, and I'm not convinced that it is this time. So unless we can find some conditions.
And we could put those, I could say we could put those conditions on. My concern is, how do they get enforced? If there is no bylaw enforcement on the weekend, then how do they get enforced?
Yeah.
So if we have serious concerns about it, we have the power to put the conditions on. We can do that. It's just a matter of who's upholding them.
Right. And if we don't have all the answers at this time, we may offer a deferral such that the applicant can come back and hopefully discuss with the residents. Because I do think, you know, a little bit of noise on a Sunday afternoon between, you know, 2 and 4 or whatever have you for a ceremony, they tend to be brief, but after the ceremony there's a reception, and the receptions can be a little bit louder. So I need a little bit more assurance here in order to allow that.
I think the problem is, how do you prevent spill out into this area? It's obviously nicely landscaped, so people inside of a banquet hall, or, you know, I've been to a wedding in a rural facility that's in a semi-tent sort of thing, but they have an outdoor patio associated with it in the middle of nowhere. And so people do go outside, they get hot, whatever, they go outside, they want to smoke or whatever. That happens, and I don't know that we can prevent that through some conditions. I mean, even as an operator, I don't even know how they could enforce it. People go outside in parking lots all the time of a banquet facility, right?
Yeah, and I do take the neighbor's submission that the patio, in relationship to the rest of the built form and the commercial zone, is a little bit close. I mean, it abuts right up against the residential zone, and I can understand how that. I do take the applicant's submissions that the noise is a problem. If they're inside their house at night and they hear it, I don't think that's something that's made up. So.
Sorry, may I just make one
No,
short comment?
sit down, please.
So I don't know if you'd feel comfortable with a motion with some conditions, or we can send this back with a deferral, or we just bring an outright refusal.
Madam Acting Deputy Secretary Treasurer, can we put a time limit? I know we can put a operation time limit. Can we put a period time limit on it? We can. That was the other option,
Yes.
is you try it out
Thank you.
for a year.
With the limitations, come back, and I'm sure if it's an issue, the residents will be back.
Yeah.
What limitations do you propose?
The limitations would be that the ceremony, so that it be permitted to allow religious ceremonies between the hours of 11 a.m. and 7 p.m., I think is reasonable. There is to be no food or beverage served on the patio, and any seating is temporary. So it looks like they also sometimes have an arch of sorts. So any seating / accessories for a cultural religious ceremony be temporary. What do you think?
Yeah, no, for sure. And a time limitation to see how this plays out.
Yeah, for the period, I would do a period of 1 year.
I would do 1 year as well.
Yeah.
And
then you reassess.
well, the committee reassesses, because then at least there's a little bit of oversight beyond just telling the residents to call 311.
So how do we reassess it then?
The period would be up in a year, and they'd have to reapply for permission beyond a year.
We'd be able to reevaluate in 12 months' time, and hopefully, too, if there are issues, we'd have some evidence to support that. So, whatever have you, that they'd be able to file to make that case that it still works, or maybe hopefully it does work, right?
Yeah, I mean, the onus is on the applicant to make it work. If he doesn't uphold this, and we hear next year, we're sitting here with the same people and we're hearing that it's an issue.
Absolutely.
Okay, I looked over their letter, and basically what you're saying is, okay, fine, they're saying that this is what's going to happen, we're going to hold them to it.
Yeah.
Okay, that's fair.
Not yet. I'd have to propose the
Let's do a
motion.
Yeah.
Okay.
Just pull up their letter, just quote it, and the following.
Do we want to quote the actual letter with the date,
no,
or
you
just
don't
the
have to-
conditions?
Yeah, well, you can say, subject to the terms of their letter. Now, staff, what would we do? They've got a letter, right? They're saying that they're going to do all the things in their letter, no food and beverage service, all those things, right? Can we tie them to, as if that were a staff report? What do we have to do specifically?
Through you, Mr. Chair, if you tell us specifically which conditions you want to impose, we can add those to the decision.
Okay, I'll take a kick at it. I would like to make a motion for approval of this application for a period of 1 year, subject to the conditions that are included in the letter dated July 25th, 2024 from ZB Hospitality Inc., York Mills Gallery. Specifically, the conditions would be that we start with item number, sorry, I went too far. I'm sorry. Start with number 1, that it's only used for cultural and religious ceremonies, the outdoor patio area we're calling it. That the number 2, the patio will be exclusively for religious ceremonies and will not host any other type of events. Ceremonies will be scheduled between 11 a.m. and 7 p.m. Ensuring, well, I don't need to put the ensuring minimal, that's their rationale. That number 3, no food or beverage service on this patio to be permitted. That it's a temporary setup for these ceremonies, including portable chairs and an arch. And that once the ceremony concludes, guests will move indoors for the reception. Is that sufficient? Does everybody think that's appropriate?
Yeah, I mean, for good measure, we may include just the compliance with applicable bylaws, because
Yeah.
I'm sure there's noise bylaws that could be helpful.
Kind of goes with.
That
But
the
it goes
owner,
without saying.
that the
You know, some of the-
applicant agrees to comply with all applicable city bylaws.
It's sort of it's redundant.
kind of
to
redundant.
Okay.
Chair's point. I
Yeah.
apologize.
Never mind.
Retract that.
Sorry.
Okay,
Good
so we
motion.
got a motion on the floor
I'm-
incorporating, motion to approve for a period of 1 year, right?
Yes.
What's going to happen at the end of that 1 year?
At the end of the 1 year, the permission expires and they have to reapply.
Okay.
Or
And-
hopefully prior to a year if there's
Imposing
more.
the 4 conditions that are in their letter to the city.
Yes.
Dated July 25th.
What they've
Okay,
committed
everybody
to.
understand the motion? Staff understand the motion?
Yep.
All right,
Okay.
Do we have a seconder?
I'll second.
Mr. Allison? Okay, so we got a motion on the floor. Seconder. Unless there's further debate, those in favor of that motion? All right, so it's approved. Thank you. Thank you to the residents for your submissions. Congratulations to the applicant for the temporary approval. And let's move to item 18. Item 18 is 16 Goodwill Avenues, 9 variances. There's two forestry reports, there's a staff report. And there are, amongst the variances, there's a proposed front yard setback, building length, height of side yard, exterior main wall, and height of side yard, exterior main wall facing east and west, plus others. The variance 6 is recommended for refusal by the staff report, and they're also asking that the proposal be in a substantially accordance with certain drawing plans. All right, that is, there's an applicant. Are they online? Can we put them forward?
Yes, good afternoon, Mr. Chair.
Hi there, so could you please state your name and address?
My name is Nafisa Zangiabadi. Address is 30 Apple Orchard Path, Thornhill.
All right, any changes to your application?
Yes, we want to make some modification to variance number 6 as the staff had some concern with that. So we want to reduce the platform area to 9 square meter.
9 square meter, okay. All right, I think we're gonna need a presentation, right? Because we got this, is this completely in accordance with the staff? There's no, is that in line with the staff report? Let me check. Okay, so they said to refuse number 6. And you have a reduction, but let me, what do we have on number 6? If you could clarify there. number 6 says that the proposed area of the rear balcony is 15.56. Permitted maximum area was 4 square meters, and you're going down to what? What are you doing in 9?
Right, going
So I think you better do
9 square meter.
She's going to have to do a presentation, right? Because she's
Sure.
okay. What? Well, we don't need a full-blown presentation necessarily, but why don't you start? You've got up to 5 minutes. The big concern is really
Sure.
on item number 6. Okay, so maybe you could focus on that, but you have up to 5 minutes if you want.
Sure.
Okay.
So this application is to construct a new 2-story dwelling with a rear cabana and pool. If you pull up the supporting material, you can see that most of our variances are caused because of the shape of the lot. The front yard setback is measured to the shortest part of the lot to the corner of the building. The rest complies. We have the variance of length, which is only 2 feet more than permitted, and it's only one small portion in the front. In the next page, if you go. That portion that I highlighted with yellow. And then we have the height variance. We do comply with overall height, but we have the main wall height variance, which is within the approved decisions of the area. And then the same goes with the front stairs, a little projection to the front yard setback due to the shape of the lot and where the established grade is. Then we have the variance of coverage. But the cabana is included in the coverage, whereas the building footprint itself, the main building, is 27%, way less than what is permitted. And then we have 2 variances related to cabana at the back. And again, it's because of the shape of the lot, the rear yard setback is measured from the shortest part. As you can see, the variances are very minor in the nature, and whatever we're proposing is within the character of the neighborhood. There's no objections from the neighbors. We decided to reduce the balcony area as the staff had some concern. We did some research in the area, and the area of the balconies that has been approved are all under 10 square meters. So we decided to keep it within that limit. And the owner is also prepared to add a privacy screen for the balcony to address staff's concern for the privacy. However, as I said, the decisions in the area for the rear balcony are under 10 meter, almost all of them. There's no side yard variance, no rear yard setback variance. As I said, the number is technical. The building is 27%. The staff is in support except for the balcony, which we just reduced, and neighbors also had no objections. So I think variances are minor in nature, and with reducing the balcony and adding a privacy screen, we're complying with the staff recommendation for the privacy.
Questions? Mr. Allison?
I wonder if you can address the tree that was brought up in
Yes.
the forestry memo.
Yes.
Why can't that tree be saved?
Okay, so first of all, that tree is a big tree, and even without any variances, that tree is going to be impacted. And if you look up at the forestry memo, you can see they have no objections to the variances, and they acknowledge that the variances doesn't have any effect on the tree. So even as of right condition, with no committee of adjustment, if even everything complies with the bylaw, the tree is going to be impacted. And they ask that put the condition, number 2 condition for the tree, and we're going to get a tree permit, and we're going to deal with urban forestry at the time of building permit. And if anything needs to be done, will be done at that stage.
Okay, thank you.
Other questions? All right, let's go into committee. Thoughts? Marzieri?
Through you, Mr. Chair, if my colleagues don't have any comment, I'm ready to make a motion.
Comments? Go ahead.
I don't have any specific concern with this application other than variance number 6 and with the revision that the applicant is suggesting. I am comfortable to make a motion to approve this application as amended. So the area of the second floor balcony reduced to 9 square meter with addition of the privacy screen up to 6 feet with the condition of community planning report and also urban forestry condition number 2.
Can we get clarification on the privacy screen location?
On the east side. On the east side, I believe it's because it's on one side of the building, the balcony. So it, if I'm right, let me see the north side.
Okay.
Sorry, it's on the west actually, because the north is at this side.
The west side. Do we have that right? Just make sure we got it right.
Sorry, let me.
Hard for me to see.
It's the east. Sorry, it's the east. Yeah, I was confused with the side plan. So it's on the east side.
All right. So privacy screen on the east side,
On
and
the
you got
east
it in
side,
accordance with
6
the
feet
staff
tall.
recommendation on the site plan.
And cabana
Cabana
to be
roof
developed
plan drawing
substantially. With
submitted, and subject to that reduction. So they asked for the removal of 15.56, and now it's down to what's number 9?
9 square meter.
And you're okay. So that's the motion.
And sorry, Mr. Chair, the privacy screen is on the second floor balcony or on the ground floor deck?
On the second floor balcony.
Got you.
That is related to the variance.
Okay.
Does this mean you're going to second that motion?
Yes, and forestry condition.
No, I just question whether the privacy screening was really necessary,
variance, yeah.
given there's no neighbor objection. Because it does create massing in bulk, but it's small. Could be a nice planter. I'm happy to second the motion.
Okay, so we got a seconder. Those in favor of the motion? Okay. Those opposed? Okay, so it's approved. Congratulations. Now, I think the next thing we should do is move to, how many people do we have on number 26? Do we have people, who's in attendance here? Like, what number are you here for? 26. You're here for 26? We got somebody over there. What are you here for? What number? 21? Nipigon. Which one is 25? 25 is Nipigon. 26. We got two. How many people do we have on the line on 26?
Through the chair, we have one.
One person. Okay, let's deal with 26 first. Let this. No? I see shrink. I think we deal with 26 and we'll take a break. Okay, so we're going to go on to 26. Let our patient residents leave for dinner when we do. Take a break. Okay, so number 26 is 160 Teddington Park. There's 11 variances. This is to construct a new 2-story dwelling. It's a detached rear yard ancillary built. 2-story detached dwelling with a rear yard ancillary building, a garden room. There's a forestry report. We got like 19 letters of objection.
I'm going into committee, just so no one talk particularly loud. Thanks.
Who?
Oh.
Who's that? I don't know what that is, but I'm just going to ignore it. We've got a staff report, we've got a TRCA report, and of the 11 variances, we've got variances dealing with east, west, rear setbacks, and building height, and all kinds of other things. And we just summarize the staff recommendation that they want modified variances of so many modifications. So we're going to go to the applicant to see what the applicant is doing in respect of these modifications, and then they have conditions as well. Okay, so let's hear from the applicant's agent. Are they on the phone?
I am on the phone. This is Jim Pfeffer from 95 St. Clair Avenue West in Toronto, and I want to thank you very much for hearing us early. It's really appreciated by all, I'm sure. So I have, of course, seen the staff report suggestions for modifications, and we would like to accept all of those modifications. I'd like to highlight to the committee that the first one that the city planning suggests is, I believe, a typo. They say modify variance number 1, and I believe that they are meaning to say modify variance number 5.
The east side yard setback, they say recommend modify number with minimum east side yard setback. I thought 1 was the east side yard setback. Yeah. Oh, I look at the public. I always look at the public.
Oh, wait a minute. Oh, wait a minute.
Okay. So staff got it right? Okay.
Oh. Oh, okay.
Good work to our staff who got it right. But you're willing to
good work.
accept all their modifications, is that correct? And their conditions?
Yeah, we're good with their modifications and their conditions, and I'd actually like to ask the committee to impose 2 more conditions on a decision.
All right.
And I sent in a cover letter to the committee, and those conditions are set out in the cover letter. One of them, the committee has opposed on a prior job. It's on the last page, and that is, the owner will retain a professional engineer licensed to practice in the province of Ontario as their grading consultant to prepare a site grading plan, undertake field review, and issue a lot grading certificate to the satisfaction of Toronto buildings. So every building permit application needs a grading consultant. It doesn't have to be.
Before you get into the specifics, why don't you just, because we'll have to make a note of this if we go along with it. So engage a site grading consultant.
An engineer as a site grading consultant.
Engineer as a site grading consultant. Okay, so that's the first one. And then what's your second one? And then we'll let you, because you get 5 minutes, right? So you can explain all this in your 5 minutes, but at least if we've got it. Engage a.
And then oh yeah.
What's the next one?
The next one is just 2 paragraphs below. It's no part of a shoring system used to retain the edges of the excavation will be located within 0.75 meters, which is 30 inches, of the west or east side property line.
Of the west side property line? I'm not reading from it. I'm just sort of. I can only.
Yeah, no part of a shoring system used to retain the edges of the excavation will be located within 0.7 meters of the east or west property line.
Okay. People understand that? Okay. Staff have taken note of this?
Through you, Mr. Chair, I've taken note, but.
We're not bringing the motion.
Okay.
We're just noting it so that if it becomes part of the motion, because it can get confusing once we go through all this. We've got neighbors here, or, a lot of stuff is going to happen. So just, if you got it. All right. Okay, so you got 5 minutes. Let's go. No?
Okay.
Well, maybe before you go, I see my esteemed panel members have questions. Right?
I just want to clarify with the applicant. Can you provide us, as part of your presentation, an explanation of where this application is coming from? Like where, I know it's been to T-Lab. I want the Reader's Digest version of where we're at with this application. What approvals did T-Lab grant, and where are we now in terms of what's being asked of committee? Can you incorporate that into your presentation?
Otherwise, you're going to get a lot of questions, I would say. So just to make things go more smoothly for you, put the context together for us. It's part of your presentation. It may be hard to do that on the fly if you haven't already planned for that, but if you do that, it'll make it easier for you, okay?
It's super easy. This is a de novo application. It has nothing to do with any application that came before it.
Okay, so let's go with let's start our clock now, and you've got 5 minutes.
Okay, so in front of you is a rendering of the front of this building. I'd like to say a couple of things about it. First, I'd like to acknowledge that we're not in the middle of the forest, but we as architects have prepared this drawing to highlight the building, and that's what you're looking at. The building that you're looking at is a big and substantial building, but it's very much in keeping with the estate-style homes that you see along this street. There is no variance required for the main wall height, so that primary volume that you see is at an as-of-right height. It's a hip roof which recedes in perspective from all sides, and that central part of the roof steps down to those side portions. So it does actually have a little bit of that cascading effect as well. Another thing I'd like to point out about this building is that the garage is really not very visible at all from the street, which we think is salutary, that there isn't that impact of parking on the streetscape. If you go to the next page, it's a site plan for the project. And I'd just like to point out a couple of things there. One is that red and blue dashed line, which is the footprint of the existing house and concrete terrace of the existing property, which go almost to the rear property line. So the building and development that we're proposing, notwithstanding the fact that we do have an extension of the basement to the rear, is actually going to have a larger yard and more green space than the existing property. By making a civil engineer being the grading consultant, you're going to guarantee that the lot grading is actually, I'm sure, going to improve the drainage conditions for this lot. The other thing that you'd see on this lot line is there's a platform variance for a 0 side yard setback. For whatever reason, the zoning examiner has identified that walkway on the right side as a platform and given us a variance for that. On the next page, you see the context of this neighborhood. You see these really large estate-style homes, really big properties. The house that we're proposing is very, very much in character and in keeping with the massing, size, and height of homes you see here. On the next page, you can see the same thing in an aerial view. And in that aerial view, you see off to the right-hand side, you can see we're beside a parking court, a single-story building right on the property line against our rear yard. And then more to the west, on the left-hand side, you can see we're in line with the front and back of existing buildings more to the west. So we're maintaining those patterns of open space on this block. On the next page, you'll see that, and you can come back to this if you want, but you can see that in this immediate context, how we fit next to these two houses immediately next to us. And further, on the next page, in terms of height, we had our surveyor go back to the properties and survey the top of roof elevations of these two houses, the one immediately to the west and the one immediately to the east. That roof of the gable that faces the side lot line of the house to the west, that's 60 centimeters higher than the roof elevation we're proposing. And on the right, that roof is 2.28 meters higher than what we're proposing. Right now, there's a bungalow on this lot, and we're proposing a 2-story house with a hip roof. So when you're looking down the street, there's going to be a change to the streetscape in terms of the fact that you can barely see anything there now. And instead, you're going to see that elevation that we proposed between these two houses a little bit shorter than each. Is that going to be a change to what someone's going to see as they're walking down the street? Absolutely, it's a change. Is it a change that should be considered unacceptable? Certainly not. On the next page, we've got the variances for the neighborhood. It's hard to do an apples to apples comparison here because in this block, the block widths vary. On the next block over, there's a different sort of pattern. However, 46, the next block over, got an FSI variance of 0.628, almost 0.63, comparable to what we're asking. On this block, across the street from us, some wider lots, they got smaller FSI variances, but the houses are in excess of 800 square meters, so much bigger than what we're asking for. The city planner found that what we were proposing was in keeping with the zoning bylaw and the pattern of development in this neighborhood. In the next pages, you can see both the screening in the backyard and the substantial homes that we are in keeping with the size and scale
So
of on
now
this
your
lot.
5 minutes is
Thank
up.
you.
Thank you.
Thank you very much.
All right. Panel members, questions of the applicant? Okay, we'll get back to you. You'll still have some time. Let's hear from the residents. Please come to the podium, state your name. And once you're there, also state your address.
My name is Vicki Hand, and I'm a resident at 150 Teddington Park Avenue, immediately to the west of 160, formerly the Southern House.
Okay, so you have do you have an arborist with you?
Online, she is not making a presentation, but her report was submitted.
Okay.
There are 3 letters of objection that were for some reason labeled as letters of objection. One of them is the arborist report, one of them is a planner's report, and one is the TPR.
So so you've got 5 minutes.
Correct.
You can involve anybody else during those 5 minutes, but once your 5 minutes are up, so if you have an arborist that's helping you, just call for them. They can pop in. But are you the only one speaking during these 5 minutes?
At the present time, my understanding is that only Terry Mills will be speaking, and Terry will be coming after me.
Okay. But just in respect of your 5 minutes, you have 5 minutes.
Thank you. I'm going to take
it for whichever, like if you have
Thank
an
you.
arborist or somebody else you want to involve, but I take it from what you've just said, you don't have anybody else. It's just you for your 5 minutes.
That's correct.
And the next person will be speaking 5 minutes and so forth.
That's correct.
Okay, great. So let's start the clock, and you've got 5 minutes.
Thank you, Mr. Chairman, and committee members, staff, and other participants. I request that the variances for 160 Teddington be denied, but another option is to defer your decision to a future date in light of the deficiencies in the plans and their incompatibility with our block, which I will discuss. There was no consultation with the neighborhood by the applicant until after the hearing announcement was published, and discussions have been fruitful but incomplete. And the applicant keeps moving the goalposts by informally changing variances on us. And we assume the committee, like us, can only work with what's been publicly posted. We haven't seen the staff report, by the way, if it's available. Point number 1. In 2022, this exact property, different owner, requested approval of an SFI of 0.522. It was ruled not in keeping with the official plan and the zoning bylaws, and Terry Mills, the planner, will speak more to that. Our block has unique zoning properties, and that was recognized by TLAP. The applicant has used irrelevant properties that are not in our block to calculate, quote, a normal range of FSIs. In our specific block, the FSIs are all under 0.50. There's one that looks larger, but that was when the property at 177, I believe, they were going to renovate, and they decided to demolish and rebuild. It's under 0.5. They're asking more than 60% over the 0.35 SFI allowed, which is a major variance. There is deficiencies in the plan to take the precedent that was set in 22 under consideration. The plans and variances are putting the cart before the horse. Setbacks and therefore variances, particularly in this treed area, cannot be determined without a tree protection plan. We have to assume there is no tree protection plan in place because no document has been produced by the owners to date. Revised plans have no legends. All that exists is a tree inventory. The plan is deficient. Setbacks are not realistic. Schematics do not reveal the extent of the retaining walls along the west and the east portions. There has been some unfortunate modification of the west side, but again, it's not in writing. The size and design of the rear of the second story implies we will have an elevated platform looking directly into our backyard, stripping us of our enjoyment and privacy. And even if the backyard hedge is retained, it will not screen any second story windows or balconies or green roof from peering into our property. And for both our sakes, for mutual privacy, I asked the COA for complete privacy screening on the second floor balconies, green roof, privacy glass on all the windows facing east and west. There's also a potential to breach the allowable variances due to this platform canopy construction because it will be a green roof and therefore will be able to sustain a great deal of weight. The back hedge is priceless in value. This magnificent 15-foot-high privacy fence is on 160 side, and both the original and revised plans shows walls all along that side. Informally, the applicant has agreed to remove the west retaining wall, but we need you to clarify. The plans contain inconsistencies. There's little or no room in the plans for existing plantings given the above and below construction process combined with the requested setbacks. Future plantings will be limited. You can refer to Judith Wright's report, page 6, all 3 notes as they refer to urban forestry's tree replacement requirements. The plan and variances do not take into consideration the possibility of restricted plantings in the future. For example, and Jim, the applicant did point out the first page of the supporting material shows a house built in parkland, devoid of other buildings. And it shows plantings on the site plan, which was page 2, and it shows, again, it shows trees that can't be planted. We will have a wall beside us, 3 times the size of the backyard hedge, blocking out our east light, no view of the trees as we enjoy now. And it is the FSI and the massing of this property that will go basically edge to edge on the property lines, well, as you noticed perhaps in one of the photographs, that all the other buildings beside it are well stepped back. There are 19 letters of objection, including neighbors, Rosedale Golf Club, an arborist report, the planner, Teddington Park Ratepayers Association. We are objecting to these variances to protect the street's beauty, proportion to protect the street. You can look at the FSI, you can look at the massing, it will be out of proportion to the street, and it's a streetscape we want to retain. The beauty of the property today is the direct result of its tree canopy and protective privacy hedges. We are willing to work together with the applicant, but not to the detriment of our neighborhood streetscape. Thank you for listening.
All right, questions of the resident? No.
I'm a bit hard of hearing, so I hope you don't mind.
Sorry, I try to keep this microphone as close to my mouth as possible, but effectively you're done. Everybody's fine with what you said. They don't have any questions. You can sit down.
Thank you.
Thank you. We got another resident?
Yes, but before I speak, there's another person on the line, our planner, Terry Mills.
Planner Terry Mills. Oh, the planner Terry Mills. Okay.
Yeah,
So-
and you have my letter. Yes.
Okay, so like the way it works, so are they speaking for you? Who are they speaking for?
On behalf of the residents,
So are you speaking too?
I'm one of the residents, yes.
You're one of the residents, you're gonna speak, so. Okay, so we had, just give us a name of somebody you're speaking for when you come up, because technically, right, like you're supposed to, unless you're a resident, if you're like a consultant, you're speaking on behalf of somebody, so we need a client. You can't, he shouldn't be speaking on behalf of you because you get 5 minutes. He can have 5 minutes too, but I want him to identify at least, you know, is he a ratepayer? Is he on behalf of the Ratepayers Association? Who's his client?
Terry is working with the neighborhood association. He's been with me many times in the past.
Okay. Well, I'll let him talk. Why don't we put on the person on the phone, and if he can speak and just identify his client of who he's speaking for, please.
Yes. Okay. It's Terry Mills here, and I'm a registered professional planner, and I've been retained by the Hands. You heard from Mrs. Hand, and they live at 150 Teddington Park Avenue.
So,
by the way, my address.
Hold on.
Sorry, yes.
So you can't do both, right? Like you get 5 minutes per person. And either you had the 5 minutes or she has the 5 minutes. You don't both get 5 minutes because that's 10 minutes. So if you want to say you're representing somebody else, fine, you can have 5 minutes, but you shouldn't have 5 minutes on behalf of the Hands because the Hands already spoke for their 5 minutes.
Okay. At the same time, I have been involved in this project with the Teddington Park Residents Association.
So are you going to speak
And,
on behalf of the Teddington Park Ratepayers Association?
Yes, I will, because Scott
that I can
Stevens
accept.
is.
But you see, we got to
Okay.
be strict. Like you're a consultant, you would know. Like we have 5 minutes. If somebody hires a consultant and they want this consultant to speak for 5 minutes, that's the 5 minutes. If they want 2 minutes for the consultant, 3 minutes to himself, that's the 5 minutes. So we're going to take it that you're speaking on behalf of the Teddington Park Ratepayers Association, right?
Okay, certainly, yes, okay.
Go ahead. You've got, did we get your,
Yeah,
you got your,
and
name, you got your address?
Yeah, my address is 101 Roehampton Avenue, Toronto.
Okay. Okay, go ahead.
And if you could go to my letter, I have visuals in there, and I was hoping we could have the visuals up, and I'll use them as I speak. Anyway, I'll get started while you get to page 1 of my visuals. Just a second here, okay. So the subject property we were dealing with is number 160, and we're dealing with the east end block of the Teddington Park Avenue, which is a different block than any of the other part of the street in the neighborhood. And the aerial photograph, if you have that up there now, getting to them, okay, it identifies that. Now, it is an extraordinary block, as we've heard already from the architect, and all the neighbors is a street park as well. They walk while they're walking the dogs and so on. It's very well treated. It's again got stately houses, etc., and a very interesting relationship to the ravine. And if we move to yes, so that's my first visual, and you can see that it's zoned RD. Frontage 22.5, which is different than the rest of the area, and it's a significant difference in that there is actually no building length and building depth requirement. On the other hand, a building, once it's beyond 17 meters, is affected by 7.5 meters side yards. If you move on to the second slide, this one we heard already and saw they had their chart of the neighborhood of what they've drawn upon for data. Now, I must say I was involved with the earlier TLAB hearing, and that was on behalf of the Teddington Park Association, and provided evidence there. And that decision, as you heard, by the way, they were asking for 0.522, and that application was referred. It was refused, and I've included in my letter to you that the previous decision file on this that you have. If you go to page 17, paragraph 15, you see what board member Yao's decision spelled out. Now, what's of interest in this block, by the way, is that one thing he said was he preferred my study area, which was strictly this block because of differences in zoning bylaws and zoning and other matters. And so that is really the appropriate context he identified after a 3-day hearing or during it. And the chart I have is basically zooms in on this block, and the highlighted in yellow, you see the FSIs that have been approved or built. In the one case you've heard already, one of these was actually one application went in for renovation, then it changed to new construction, and they again came in at the end of 0.47. And of interest, by the way, just last month in June, you actually dealt with another house on the street, I believe it was 169, and approved 0.49. I must say the association uses a threshold for density for this block of 0.5 as being appropriate. If we flip to the third diagram, we see the elevation of the house, and they're asking for a height variance, and there's no need in planning for the additional height. And it is a requirement when you have asked for additional density or height that you have to provide appropriate planning justification, but there is no justification for this additional height. We end up here with actually what appears to be a 3-story house. in that attic space up there would be habitable. On the other hand, it will have trusses in it, so it doesn't get counted in the FSI. But if it were counted in, if there were trusses up to be put in there, you're actually looking at a building mass that actually has an FSI of 0.805. And whether it's habitable or not, it reads as a 3-story house of that bulk. Meanwhile, the prevailing house form in the neighborhood consists of 2 and 2.5-story houses, and they use a modest 45-degree angle pitch, and these recede back. On the other hand, they are using a 60-degree pitch, so the majority of their roof is flat, and the slope part
Your time's
ends
almost
at
up.
the ridge. Oh dear, ends up being very close to the main wall. I've provided photographs, and we have on the 2 pages down, you see a chart there, a diagram that shows the amount of green space in the setbacks, which are...
Your time is up. So let's...
Okay, well, I'll tell you what, I think you have a lot of information from me, and I appreciate your...
Just hang on. Let's see if we've got questions for you.
Certainly.
Panel members, questions? No questions? All right. We do have a question.
I had a question with respect. I realize that there is no variance for a front yard setback, but to address the variance with respect to FSI, I'm just wondering about your opinion on the front main wall of the house as it relates to the street and both of the adjacent properties.
Okay, in terms of the front elevation, and one of my points was there's no need for the additional height. It could be kept to the bylaw. We heard mention that the house to the west is taller, but also by 0.5 meter roughly. But there's also a change on the established grade level by 0.5 meter to that lot. Again, when you look at the house to the east, it has the slope, it's a 45-pitch roof. When they talk about the building height, you're only talking about the tip of the ridge. In this case, we're dealing with the fact that the majority of the roof is actually a flat roof. So it's a very substantial building. It doesn't taper off and slope back. In terms of the sides, again, the property has a substantial hedge, as you've seen in the photographs, which acts as a very good buffer with the neighbor. And we have on the east side a number of trees that on either side of the boundary. That house, these had been on the listed property until Doug Ford took every listed house off. But it's still regarded as a house with of heritage significance or cultural value. And those trees are quite important. If you look at my last photograph, you can see there's trees between, or last slide, you see there on the angle, you see there's that tree sort of forms part of the curtilage for that whole, what they call the castle, the large house. And all those trees would be proposed to be removed. And so, basically because of the density, they have ended up, sacrificing all the side yards. And the arborist has concerns about that. And if they actually, by the way, the plans they have put forward to you saying 0.56, you have a second letter from me. I could only calculate on the plans when I overlaid them on top of each other, but their plans do not show 0.56, they show a higher number. Okay. So I'm hoping, though, if they bring it down, we'll get the side yards back to a reasonable level that will protect the soft landscaping that is the buffering and curtaining for the two sides. Sorry for that being so long.
No, very good. And then just a quick clarifying question. The diagram that you have up there, in the planning rationale diagram there, so my understanding is those those kind of green squares at the back that kind of taper in the rear addition, that is demonstrating the bylaw requirement, which in my understanding is after a certain depth, the side yard setback increases to 7.5 meters. Is that?
That's correct.
Okay. And is the red line?
The other thing, by the sorry.
Yep.
The red line was used by me to define, the front yard setback is the front red line. At the back of the big square, that's the 17-meter length at which the 7.5-meter side yards kick in, and the upper line is the rear yard setback. Okay, and so therefore the white patch in there is what you would call the as of right footprint.
Okay, and
again,
where would you say the rear main wall falls on that diagram in relation to that diagram? Is it around that red line at the back, or slightly
the
beyond
two-story part is halfway between those two red lines, very close to each other. One other thing you have to keep in mind is, by the way, underground in the whole of the backyard, going to within 2 meters of the back, is an underground swimming pool and an underground parking garage for 4 cars.
Yes.
Which, if you read the arborist report, affects all the possibilities for trees and hedges. And you can't even do replacement trees beyond probably 1 tree per side because of the requirements of forestry would have for the proper amount of soil cell. And there are other issues as well as to how do you handle your stormwater off of basically a hardscape backyard. And it would probably require swales, at which point you can't even plant trees and swales. So
okay. So the additional building depth that you're saying would require the removal of otherwise healthy trees?
And on the side yard setbacks, yes.
Okay, thank you. No further questions.
And the edge, okay.
I don't know if I want.
Can I just?
But I guess I should ask some questions. You referred to these previous TLAB decisions, right?
Yeah.
Maybe you can clarify what's going on there. What happened at the TLAB in the past? Pardon?
Well, the last C-Lab was a different house design, and then the property got sold afterwards.
So those those aren't really relevant. The reason I'm asking you is because we asked the applicant said they're not relevant. Are they relevant?
I think they are relevant for a number of things. One, what is the study area? That, in other words, what are you comparing to in terms of respect and reinforce existing physical character of the neighborhood? There's the Ted Yao, the panel member's decision identified that the density was a significant factor in all of it. And at that point, he was looking at 0.522. And the higher density starts having the impacts on, on these setbacks. And what they are there because on this size of lot, the 22-meter and plus lots, it's assumed you're dealing with sort of an estate property, and you're expecting that one can build longer as long as you respect the side yard conditions.
Okay, so sorry, I'm not stupid, but it's really hard for me to follow all this, right? When we've got 4 previous TLAB decisions, a previous committee of adjustment decision, you were involved in all those, right?
Yeah, well, it's actually one TLAB decision, and then it's the review of it, which was even longer, which again confirmed the decision.
It's just hard for me to follow all this. I know Ms. Casson raised it, but let's make it simple for us because we're going to have to make a decision on this. We've got so many other previous ones. How?
Agreed.
Just summarize it for us, really. What
Well,
are the issues that they found that you think we need to find?
Okay, the big ones are its ability to maintain the buffering of the house on each side. And I must say, from the start of discussions we had now, I would think with the architect for the scheme.
Okay, so
the
that's
neighbors,
the first one, the buffering
the
on
best
each
thing would be
side.
probably to defer it and
Let's go
see how
through-
many
sorry
things
to
we can
interrupt
straighten
you,
out
but
for
I
you.
just want to understand, let's go through quick bullet points. Buffering on each side, you think TLAB dealt with that. What else?
So you're saying the TLAB is part of it, right?
Well, no, I'm just trying to understand because look, we don't want to be like, I mean, I've got very esteemed panel members and they have a lot of knowledge of these issues, but even they, you know, may want to know some of the answers to things that I'm asking, which is, what did T-Lab do that you think we should do? And you're saying T-Lab did buffering on each side. What else did T-Lab do?
T-Lab refused the application and turned down all the variances.
And they.
I think what you should do, which would be better, would actually ask the applicant if he would defer, because I do believe in this neighborhood, I know that the neighbors have in the past had good constructive conversations with people who are interested in building.
But he's here now, so
and come back with something
he doesn't
simpler.
have to defer, right? Like we can decide.
Agreed.
We can defer it, but
Yeah,
he's already done his presentation. He's like in the middle of his application, so there's no point in asking him. But I mean, I'm just struggling with. I mean, you made an extensive presentation. We know that there's these T-Lab and Committee of Adjustment decisions. Is there anything else that they did besides buffering on each side and refusing? Is there anything else?
You're talking about the T-Lab, or you're talking about this application?
T-Lab in the past.
Well, the T-Lab didn't have to deal with the underground structure because there was none. Okay. But it was a 3-day hearing, and it's all there to be read. And as I say, it came down to a refusal.
Okay.
And the basis of that was the house was so big to fit on the site that it could not set itself in a fashion that fitted, the context.
Were you did you testify at T-Lab?
Yes, I did.
Because there's a lot of stuff before us, right? So it's hard to get through it all.
Agreed.
The same way that you would know having been through it. That's why I'm asking you. But that's okay. I don't have anything. Anybody else have a question? Okay, let's go to the next resident, please.
Thank you. Thank you, Chair. My name is Boris Kogut. I live at 179 Teddington Park Avenue, which is 2 houses to the east of the subject property and across the street.
Okay.
I was also involved in the T-Lab.
You can talk about that, but you'll have 5 minutes.
Okay.
Maybe we'll ask you questions.
Okay. So I was also involved in T-Lab hearings, and I testified. And the key issues there with Ted Yao was that he objected to the setbacks, the side yard setbacks, as well as the front yard setback and the FSI and the height variance. Those are the key issues that were addressed in the T-Lab decision. Now, just coming back to my presentation. My message to this committee, well, first of all, there's 3 items that I have an issue with. One is FSI, the second is side yard setback variance, and the consequences of having a large basement excavation, which includes a swimming pool and a 4-car garage. The message to this committee is that the proposed application is asking for FSI and side yard setback variances that are not minor and do not respect and reinforce the character of the neighborhood. The initial building application was filed without any consultation with the neighbors, as well as without looking at the previous application, which was refused 2 years ago, which also asked for similar excessive variances, FSI side yard setback, and was met with strong opposition from the neighbors, and the application was rejected by Ted Yao. So I'll speak to the first, which is the FSI. The FSI variance requested is excessive at 0.56 and is inconsistent with other new houses on our street. Recent houses built in our block include our house, the house that I live in, which is 179 Teddington, 177 and 137. All of these 3 houses that have been built most recently have FSI of 0.47 or less. And I recommend that this committee limit the FSI to 0.47, which is already 34% over the 35 FSI that's allowed maximum today. My wife and I were able to build a house with a similar size lot, which was 6,000 square feet and still stay within the FSI of 0.47. Also, before we submitted our Committee of Adjustment application, we consulted with our neighbors, and the neighborhood association to ensure the variances were in line with what's been asked previously, customary for a block, and we only had letters of support, not a single letter of objection. On my last count, there were 17 letters of objection submitted by the neighbors for this application. My second point is the side yard setback. These setbacks are important to maintain in that they protect the trees as well as the neighbor's privacy, the adjoining neighbor's privacy, which is Vicky Hand is the most impacted. Our neighborhood prides itself on preserving our mature tree canopy, and as a definitive characteristic of our area, we have a lot of mature trees. The proposed plans filed on the city website do not identify which trees will be maintained, which ones will be removed or injured. I request that the committee reject the side yard setbacks because of the impact on the adjoining, on the trees that tend to be on the closer to property line. My third point is the size of the basement. I know there's no variance required for a basement of size. You can have a basement from one edge of the property to the other, but no variance. No variance needed. But practically speaking, when you build a basement that size, you have drainage issues, and you have to remove the trees that are on the property. And that's the issue, is the impact of this large 7,500 square feet basement with a 4-car garage and a large swimming pool. The basement excavation would at minimum injure and kill many of the mature trees, as well as have negative consequences in the water drainage for properties on both sides of 160. And of course, this is of little interest to the architect or the owners of 160 because they don't get impacted by the drainage or the removal of trees. They get to build the house that they want without really any consideration on the impact of the neighbors and the neighborhood itself. So my final question to you, my ask of you, is that the committee reject the FSI and the side yard setback variances, and that the committee requests that the mature trees on the property be protected. That is it for me.
All right. Panel members, questions for the resident? I think that's it. You're free to go.
Thank you.
Thank you. That's it for residents. We don't have any more residents. All right, so back to the applicant. Mr. Applicant's agent, go ahead. You'll have up to 5 minutes to address residents' concerns.
Yeah, well, the first thing I'd like to speak to is you asked the question, what was in this OMB decision? And Ted Yao, in his decision, basically took down 2 of the variances which were requested for the prior proposal. The rest were not discussed. So one of those variances was the front yard setback variance for the prior proposal, which we are not asking for, of course. And the second one was the prior proposal asked for an FSI of 0.522. And the panel member, Ted Yao, also rejected that. But that was for a building which was very different from ours. It had a 2-story garage coming to the front. It had big enclosed areas at the back of the building. There's very good reasons for thinking that the FSI of that building would be judged differently than what we're putting forward here. There's been some discussion about what makes sense on this block, but on this street, the next block over, there's a house, same side of the street, exactly the same size lot, FSI variance of 0.63. I think what we're looking for is comparable. Across the street, there's some wider lots that have larger houses, and I think we are in keeping with the scale of those houses. I think, can we just go to page 13 of my presentation? Because there was some discussion about, a lot of discussion actually about trees. We have suggested that the committee impose this decision on the setback of shoring because basically if you say you've got to be 75 centimeters from the property line with the shoring, the next page down, please, that effectively means it's 1.1 meters excavation from the property line. So the next page down, which has the footprints of the different plants, that shows the shoring, it shows those trees on either side, and the hedges on either side in the profile determined by the surveyor. Number one, I'd like to point out here, the trees beyond that 17 meters in length, there's the same as of right diagram on the right-hand side. Sure, the shoring is going to be at the edge of those tree protection zones, but we are not going to be significantly impacting trees, as you can see in this diagram, beyond in the back, beyond beyond that 17-meter line. You can see that 17-meter line is basically outside the canopy of those hedges, and it's our arborist's opinion that those hedges will be able to remain. So existing trees impacted by that side yard variance, which Ted Yao did not speak to buffering side yard at all. So there we go. So Mr. Mills spoke about trees. He spoke about a number of construction issues. I do show later on a shoring detail. He spoke about drainage, which is a big issue. We've also suggested to the committee that you impose a condition that a civil engineer do the grading for this lot. There are, if you go to the next page, green roofed products that we can put over this extended basement, which are actually more absorptive of water, that have a lower runoff condition, lower runoff coefficient than actual lawn does. That's the type of thing that we're going to use to manage the stormwater in this property much better than the existing property, which basically has almost nothing in the way of rear yard. They've got a huge concrete terrace and a very sprawling footprint. Terry Mills said the heights, he said something about, oh, what would the FSI be if you included the attic in the FSI? And he talked, it's completely irrelevant to what the committee is saying. There's more heat than light there. If you take a look at the size and the FSI, the scale of houses on this block, if you can scroll a few pages back to some of the images of those houses, you'll see, and if you've visited the site as well, you'll see, houses that are in the same scale. Someone mentioned the Rosedale Valley Golf Course. We reached out 2 weeks ago to them. The gentleman who wrote the letter, he hasn't gotten back to me. His issues about seeing this property from the back, completely irrelevant because there's a huge tree screening in the golf course to this property. Take a look at those houses. On the bottom, we're between those two houses on the right and left, and we're shorter than them. We are going to fit in alongside those two houses on this streetscape. If you take a look at the site plan, actually, the second page, you can see the footprint in red of the platform, 2 meters from the neighboring property, or 22 feet, rather, from the neighboring property.
Your time's up.
Thank you very much. I appreciate your time.
Questions of the panel? I just got a question on this. So you're aware that the forestry report is recommending refusal of your second variance. You're aware of that, right?
I thought the forestry report I saw
Am I wrong? Did I read
was
the
just
wrong
about asking for
Maybe I read
asking the standard condition about a permit.
Maybe I read the wrong one. Let me see if I got it right. I thought, did forestry ask for deny variance 1 or deny variance 2? 1. Okay, so they're asking for a denial of something, right? Do you want to address that before we go into committee?
Hold on, let me just take a look at this forestry report because I had not seen. If I can just take a look at that for 1 second.
Tree inventory system, tree protection plan.
Or minimum site setbacks.
Let me just see here. I'm pretty sure I saw it.
Yeah, I see it here. Yeah, so I do. So if you can scroll down to the diagram that I guess Mr. Bostock or whomever has prepared on the last page of this report. Is there on page 4 of this report? Yeah, so there's a site plan that he provides, and he shows these trees. So absolutely, those two trees towards that he's pointing to a tree with that sort of bottom arrow, and those trees will be, I would have to say, they will likely be destroyed by this project. But the fact is that the impact on those trees would happen irregardless of any project built on this site that maintained the as of right setbacks and that 17-meter depth. Those trees are going to be killed by any construction within that as of right envelope that both Mr. Mills and I showed. And then those two trees at the back, if you can just flip back to that diagram I had on, I think it was page 13 of my report, which shows, the three footprints, the existing footprint on the building, the proposed footprint, and the as of right footprint. And we can take a look at those side by side. And particularly the one, I'd particularly call your attention to the top right-hand corner of the central diagram, which is the house we're proposing. And I've shown in black there that shoring where shown at the setback we're requesting. And you can see, just if you zoom in on that corner, yeah, you can see how we are kind of close to those trees, but the amount of the canopy or that tree protection zone we're impacting is really pretty minimal. And the fact is, again, as Terry Mills has explained, these side yard setbacks, they're really basically a stand-in for a depth setback.
Okay.
And they're pretty ecumenical.
I
Like
understand.
everything that
That's
gets,
enough. It's okay. I got it. Let's.
every project along this block gets, effectively this limits you to a 17-meter
Okay.
depth,
Let-
which
let-
isn't
let's
very much on a
stop- let's
regular
stop it.
lot.
You made your point. Let's go into committee.
Okay, thank you very
Thank
much.
you. All right. Who wants to talk about this? I think Jordan wants to start. You think you want to start? You do. Go ahead.
I'm
You
happy to
start.
provide some comment. I think generally speaking, I have issues supporting the application. There's a number of reasons why. Maybe just shed a little bit of light on some of the concerns that I have. With respect to variance number 1, with respect to the east and actually 1 and 2 east and west side yard setbacks, I think that, certainly on the one side with the neighbor, the west side, there needs to be some relief. This building has an incredible depth, and I understand mainly on account of the fact that you have some structures at the back and some underground component, and I'm generally okay with that. But my concern is that these side yard setbacks there's no relief as the depth goes back, and with the size of the lot, this sort of just is my comment generally speaking about the application. This lot should not be having side yard setbacks of 0 meters. It is a very big lot, and they're very big houses, and the separation between these homes we're not talking about 0 meters, a few feet. There's a good side yard setback and distance between that. So I just think it's taking advantage a little bit too much. With respect to the rear setback, I'm generally okay with this. I understand what it's facilitating, and it doesn't seem to be affecting trees back there. There's nothing specific from forestry about the rear setback, so generally okay with that. FSI, I think again it's pretty high at 0.63. We've had some discussion today about what would be an appropriate FSI. I also think that the applicant is lucky in a sense that because of the way that the zoning bylaw is written, they are afforded a front yard setback, which I think is actually pretty generous for what they're proposing. And while I do recognize it is an as of right, the amount of density that is kind of pushed out with the side yards and the height, it does result in a rather large massing. So FSI not so convinced on. The rear platforms I didn't have any issue with. I did bring up number 7 and 8. I think the 0 meter setback is kind of ridiculous, frankly, if I might say. I think that that there's no reason that they can't meet a more reasonable setback to the neighbor, regardless if it's a deck or anything. Frankly, it should be soft landscaping. And then, you know, I think number 9, I think we got into this a little bit, and the lawyer that spoke on behalf of the Ratepayers Association had a diagram that illustrated the additional step back that would be required beyond a certain building depth. And I think while there may be some give to providing less than 7.5 meters, it was just ignored altogether. Like the side main walls just continue all the way back. I think it could be acceptable on one side because of the way the context. There's a garage back there, but on the other side, it's the neighbor's backyard. It's open space, and I think a side main wall at that height going that far back without any relief beyond that certain building depth is not acceptable. And then lastly, the canopy, again, could be okay with it, but I just think overall there's a lot of problems with this application, mainly on the count that they've got way too big of a house on the lot that it is. It's got to be scaled down a little bit.
Okay, so does that mean that you're willing to make a motion to refuse?
Yeah, unless there's other comments.
Well, let's put the motion to refuse on the floor and see what happens.
Ms. Caston.
She'll get to talk, or you don't see things his way at all?
No, I was just going to add on to what he said.
Okay, so why don't you put the motion on, and then I'll let you talk, and maybe you'll second it. And
Sure, and Mr. Chair, I didn't mean to belay on the sort of the planning rationale, but I hope that it's helpful in providing, because I realize this application, previous applications before it, they put a lot of time into it. So I'm hoping this might provide a little bit of direction so that we can get to something that would meet the 4 tests and also not, affect the residents in such a negative way. So,
so you got a motion to?
Yeah, a motion to refuse the application.
We'll go to Ms. Casson. We got a motion to approve. You can second it. You can talk about it. You can do anything because it's up to you. You got the floor.
I think I can second the motion, but I will just say, I think, just to add on to what Mr. Allison has said, I think that the character of this area is unique in this specific area, and it's a limited area where it's very unique. And I think that in this case, the required side yard setbacks that are in the bylaw are to ensure some consistency in that streetscape. And whereas other areas of the city where we're able to reduce the side yards, and like you said, I think there could be some consideration, but not down to a side yard that you might see on a 30-foot lot. I think it's inappropriate, and the lot is plenty big enough to be able to develop a large house on. I do have a concern about the rear yard, the underground component, because not so much that there's an underground component, and I've seen it on other lots where they may have a portion of the lot is a smaller setback, rear yard setback, but it really prevents any tree planting. You'll never grow trees on any of that. So I just don't think that, I don't think the intention of the zoning bylaw was to deal with underground components to a house. It really was to regulate yards, and although it's underground and you don't see it, it has other impacts on adjacent properties and the existing property. And I have some serious concerns about that. So
Okay,
for that
so
reason, I'm
we got a
seconding.
motion, we got it seconded, and I took look at the panel members. You don't have to talk to us. I'd say I mean, our mover and seconder talked extensively, and given the hour, if
supporting.
people are, so you're supporting this motion, okay. If there's anybody opposed to it, otherwise I'm gonna just put it to a vote, all right? So those in favor of the motion to refuse, okay, so it's carried, and that, thank you to everyone for your presentations. It's been refused, okay? We're gonna take a half-hour break now. Yeah, we gotta eat. It's 6:15. Yeah. We'll take a half an hour. How we're gonna eat? Where's 25? No, let's take the break. I'm out of gas, and I think we should be. So we're gonna take a break till 6:45. And then we'll go fast. We'll give them a chance to eat too. Just gotta take a break.
Sorry, I didn't mean to go through all the variances.
No, that's fine. It was just like
The amount of time I spent, I got provide a little bit of direction.
I got a headache. I don't know where we're gonna eat. We gotta get to the food court. It takes 5 minutes. We gotta eat, which takes 15 minutes. We gotta get back. 25 minutes. I've got places to go. I don't want to hang around here. I've got actual things to do, and I would like this over.
If you have a question, you can ask staff.
Sorry, I'm going to food court. I gotta get something.
I think we guys go to Starbucks.
Okay.
Or some coffee.
Anybody going to food court?
We'll probably see you there.
Are you going to food court? Are you going to do some work or? No,
We do a good job of that, huh?
Well, you know what? I can. So let's. Sign it. That's what we should do. This is like, it's not just rubber stamp, it's not just the institution. Otherwise, we'll rubber stamp everything that's approved. Normally, you can ease it by having justifications. So, that is fine. We have, Okay, so everybody, we're back, and we are on item 19. Item 19 is 167 Downsview Avenue. 5 variances. This is to alter existing one-story dwelling by constructing a front, rear, and side split addition. Main thing here is we have a negative staff report. It's saying variances number 1 and 4 be refused. The variances here deal with eaves, projection, driveway width, chimney, and east side yard setback. All right. Where is our applicant? They're online? Okay, so put them on, please. Hello? Hello, applicant. Hello, applicant. Are they there?
Through the chair, Bevan Gray, you have been unmuted.
I'll give them a few seconds. Otherwise, we're going on to the next one. They're unmuted and they're not speaking. I'll give them like another 10 seconds, then we're going to go to the next one. We'll have to come back to them. Okay, let's just move on. Item number 20. We'll come back to 19. Item number 20 is 3 Shapo Place, 7 variances. It's to construct 2-story dwelling and a rear deck. Got arborist report, forestry report, staff report, transportation reports, and the staff report deals with variance being refused. Variance number 2 regarding the driveway width and some conditions. Of the 7 variances, they include the front yard landscaping, driveway width, and east yard setback. All right, let's deal with the applicant. Is the applicant on the line for 20?
I'm here. Can you hear me, Mr. Chairman?
Yes, I can. So please state your name. You're for 20, right? And you're the applicant?
I'm here for item. Yes, that's correct. I'm the lawyer for the applicant here for number 20. I'm not sure if it's possible to turn my video on. Happy to do that, but I'm in your hands.
You want to turn video on for him, staff? Yes? Okay. So just...
There you go. Great, thanks.
Thank you. I don't know where he is. Oh, there he is. Yes, please state your name.
You see me?
State your address, and let us know if you're making changes.
Absolutely. Good evening, Mr. Chair, members of the committee. My name is Ian Andres. I'm with Goodman's, lawyer for the applicant and owner. Firm's address is 333 Bay Street, Suite 3400, Toronto. We are making a couple of minor changes as a result of the updated transportation services memo, which I believe you have on the screen there. It's a slight reduction in the driveway width variance and a slight reduction or a slight increase to the landscape open space or reduction in that variance, which I'll come to in a moment if that's okay.
Okay, so why don't you just well, before you start our clock ticking, are you complying with what the staff have asked for in these variances? Like, that will just make it simpler for us.
Yes, as it relates to the driveway width. Well, there was 2 memos. There was the transportation memo and the planning memo.
Right.
The planning memo came first, and then transportation said that they would be satisfied with the driveway width if we reduced the width of the entrance at the property line. And so we have complied with exactly what transportation staff requested, and they've submitted a revised report saying they're satisfied and they have no more objections. I don't know where that leaves planning, but it was a transportation issue and transportation was okay with it.
Okay, so, I mean, planning had said variance number 2 and the driveway width be refused. And then, but you're saying you've dealt with that in the sense that transportation you've now complied with, so you've
Correct.
effectively, and then on the so they modified, well, I don't know, they said, should we approve, they say modify variance number 5 regarding lot coverage. Are you doing that too?
No, we're not prepared to reduce the lot coverage, and I'm happy to speak with that. So that probably is still an outstanding concern
Yeah.
from planning staff.
Okay, so I think we're going to need a presentation then, so go ahead, you'll have 5 minutes. Thanks.
Thank you. Okay, so the subject property, 3 Chapeau Place, is located on a small cul-de-sac. It's west of Leslie Street, south of Lawrence, and just north of the Sunnybrook Park playing fields. It has a 2-story dwelling today with an integral 3-car garage and a wide circular interlocking brick driveway with 2 curb cuts, which is consistent with every other house on the street. It's proposed to be demolished and replaced with a modern 2-story dwelling with a partially covered terrace. So I think you have my presentation package up there that Mr. Wengel's office had submitted. So as noted on page 1 of the package, variances are required: lot coverage, east side yard setbacks, rear deck projection, driveway width, and front yard landscape open space. If you go forward to page 3 of the package, please, which is the site plan, you'll see that the proposed new house, there's actually 2 site plans, but the next one's a little more zoomed in. The proposed house is comfortably within the permitted building envelope for the most part, which is the red dashed line. That's the permitted envelope. The only encroachment beyond that is on the east side yard side, where there's a very small encroachment at the northeast corner, which is actually less of an encroachment than the existing dwelling shown in green. And then the building does extend beyond the permitted setback in the southeast corner as well. And that's for the rear terrace, the first floor terrace and the basement. So these setbacks on the east side result in part from the unique lot configuration. As you can see, there's a circular frontage on the cul-de-sac. So to orient the house so that it has appropriate facing distance, it doesn't fit, entirely parallel with the lot lines, and that's in part why the east side yard setback is needed. But as you saw from the planning staff memo, they confirm planning has no issue with the east side yard setback. All they're asking for is a condition to build substantially in accordance with the plans, which is fine. Just quickly with respect to the rear deck projection, the entire terrace comfortably fits into the rear yard setback and the permitted building envelope. It only spans about half the width of the house, as you can see on the east side, and the portion that projects 5.5 meters from the rear wall is only about half of the deck. You can see there's a little breakfast nook on the first floor that juts out to the south. And for that portion of the terrace, it's less than the 2.5 meters that's allowed, but it's the pieces on either side of that breakfast nook that go to the 5.5. So from our perspective, that doesn't result in any impacts. There's still a very large landscaped open space in the back, and it complies with the rear yard setback. On the driveway, as I mentioned, the original proposal was to maintain the exact same driveway that exists today, which is interlocking brick. Every other house on the street has a circular driveway with 2 curb cuts, so this is very much part of the character of the neighborhood. And because this property happens to be on the inside of the cul-de-sac as it juts down, there is a bit of a safety issue in backing up, and it's tricky to back up safely out of there. So that's one of the reasons the original driveway was proposed. But we've taken a closer look at it in light of transportation's comments, and we can shave off that inner portion to get to the 6 meters at the property line, which was satisfactory to transportation. That results in a little bit more landscape open space. And our client's also prepared to do permeable pavers to make sure that there's no stormwater drainage issues. And it'll actually improve the existing condition, which is entirely hardscaping on the driveway. So again, we believe that that's an appropriate resolution of that issue. On the coverage, planning want to see the number reduced to below 30%. With all due respect to staff, we believe it's an arbitrary standard and does not reflect the character of the neighborhood. If you go to the next page, please, there's a coverage map that Mr. Wengel's office prepared, which shows that there in the immediate neighborhood, there's been 22 variance approvals above 25% coverage, and half of those, 11 in total, exceed the 30% threshold that planning is recommending. 5 of those, in fact, exceed the 32% coverage amount, and 1 is actually almost 44% coverage, which is quite a bit more than we're asking for. The other part of it, if you go to the very last page of the presentation, is that the house itself essentially fits under the 30% coverage that planning is asking for. 29.4% of coverage is associated with the above grade footprint of the house, and the terrace. If you could just go to the last slide, you'll see that if the terrace was instead simply a deck, then that would not count towards coverage under the zoning bylaw, and we would be under the 30%. But because a portion of the terrace has a below-grade space underneath it, which is part of the swimming pool, the therapy pool that our client wants, that triggers the coverage applying to that terrace space because there's built form underneath it, and that puts us above the 32%. So from an impact perspective, negligible, and it's frankly indistinguishable from what would be permitted if that space underneath the deck wasn't covered. So again, we believe that's reasonable and in keeping with everything else in the neighborhood. And the last thing I'll say, and I realize I'm out of time, Mr. Wengel's office submitted neighbor packages to everyone in the neighborhood, including all the adjacent lots and even some on Shady Oaks and on Suncrest to the south. No one has expressed any concern whatsoever with this application.
We're at your 5-minute limit.
Thank you, sir. I'll conclude there. We believe it meets the 4 tests and respectfully request it be approved.
Okay, thank you. So, panel members, Mr. Allison.
Thank you, Mr. Chair. Can we just go back to variance number 1 and 2, and if you can just take me through the changes there? I think you mentioned that there was an increase to the landscaping, soft landscaping at the front. You could just take me through to what those the changes were and what the resulting impact is on those variances.
Yes, certainly. So while we're on the notice, I'll tell you what the numerical changes are. So the variance dealing with landscape open space was originally sought at, sorry, I'm just looking for the notice. It was originally 54.81%, and we're now proposing 56.61%. So that represents about 11 square meters deficiency below what the bylaw would require, but we're getting very close to the 60%. So 56.61%, and I'll show you on the plan in a moment where that comes from.
Okay. And
sorry.
I apologize.
Yeah, the driveway width number 2. So 13.03 was the original request, and the new driveway width is, my cursor is not working here. There we go. 12.58 meters, 12.58.
Okay.
So a little less than half a meter reduction. And if we could just go back to the site plan on page 3 of my presentation package. Yeah, so it's on the westerly, in the top left corner there of the property, the westerly portion of the driveway, or the westerly entrance to the driveway. You may have to zoom in a bit to see it, but what happened was the original driveway, it's 6 meters at the curb of the paved street, but you'll see that the property line in the boulevard actually comes in a little bit to the south. And so where the existing driveway meets the property line today was 8.11 meters in width on the west side. And so we've reduced that to 6 meters, which is the dimension you'll see on that site plan in front of you. And that results in the a portion of that front yard being reclaimed as landscaped open space. And the transportation memo indicates they want us to commit to soft planting that, which we're happy to do.
Okay, and it also looks like the site plan that's been included in your presentation material reflects the modifications to the first 2 variances.
Yes.
Okay.
That's correct.
Thank you.
You're welcome.
Do we have other questions? We've got nobody here in opposition, right? We're going to go into committee then. We still have the applicant here. If we before we go into committee, I just want to make sure we've covered. This is 20, right? Forestry. Any questions on that? Okay, let's go into committee. People are okay with this? What do you think? Yeah. People are okay. I happen to know this area. That used to be, I think it used to all be one big house owned by a guy called Cortleigh. I've been on that street. A lot of my friends grew up very close to this, Shady Oaks and so forth. So being from Don Mills, you know, if it goes, I don't know if this is considered Don Mills, but it's sort of, it's around Don Mills, yeah. It's kind of, it's considered bridle path. All right, what do we want to do here?
So it just, I don't know if my colleagues follow, but I'm just looking at the transportation report and some of the recommendations from their initial request or from their request from deferral. I just want to make sure that those have been addressed.
You want to come out of committee and go back to him and ask him, or I don't know.
I
like,
know we
he
spoke to
sorta
it
said-
briefly.
He said that they were. Are we going to take his word, or do you want to?
Staff, can we pull up the Transportation Services memo from August 9th? Yeah.
Like I'm pretty impressed by the fact that nobody's showed up in opposition. Because
So they have no objections, they just have a couple of conditions, so we can make it conditional on that memo?
Yeah, I see the site plan has been updated for that 6 meters, which also to the applicant's submission increased the soft landscaping. So I'm satisfied with that. I think it's more just I want to make sure we capture everything in bringing a motion.
The residents would never let them get away with in this area, and you're in a court like that, they would be out, like the entire rest of the street would be out, unless they, I don't know, they didn't agree. Okay. Yeah.
So based on the report, it seems like we can still include the recommendations. They've done them already, but to their satisfaction, I think, just to ensure that they'll formally submit that site plan that already meets those requirements. And lastly, you see forestry.
What is forestry doing here?
Forestry
Doesn't
number
seem
2.
like they, yeah. doesn't seem-
And the planning condition. If there's any other comment, I'm happy to bring a motion. So happy to bring a motion to approve the subject application as amended. So notice amending variance number 1 to front yard landscaping area is 56.61%. Amending variance number 2 of the proposed driveway at its greatest width is 12.58 meters. Also including the condition noted in the staff report from community planning that the east side yard setback will be developed substantially in accordance with the site plan drawing attached to the report.
But it's not to the report, right? Isn't that the old one? Is it not the new one that was part of the presentation? Do we know?
They do have a new site plan drawing, but I think the east yard setback, I mean, we can tie it to the new one. Might be better.
Let's tie it to the new one.
Let's tie, yeah, good point. The site plan, it's more of a diagram though.
Through you, Mr. Chair, there are revised plans in the package from August 8th.
Oh, thank you. Yes, I do see those. Yes, let's tie it to the revised site plan received August 8th. I see that there. And yes, I do see the revision to transportation as well. And then we have urban forestry number 2. Thank you. And I captured transportation, conditions of transportation. They're just standard. They just want a submission of the site plan. That's my motion.
Staff have that?
May I
The
just
motion
add
second.
friendly addition to that. Since the applicant mentioned about permeable pavers, can we include that in the motion for the driveway?
I think that's good. Yeah, I mean, consider they're falling short on the soft landscaping. It was nice to see that. Thanks for catching that. I should also ask, do we want to tie any of the other variances to the site plan, just given the nature of the lot? No, it didn't come from. Yeah, well, the updated, yeah, okay. Sure. Yeah.
Because the driveway width at the max is 12.58, the revised. And if you don't tie it to the site plan, essentially the whole driveway could be 12.58.
Except they'd fall short on the soft landscaping, but
True,
let's do it for
true.
good measure.
Belts and suspenders.
So yeah, let's tie that driveway width variance number 2 as well to the site plan.
Substantially.
Substantially in accordance with. Thank you. Yep, that's my motion. I think seconded.
Seconded. All right. Those in favor? It's approved. All right. Congratulations to the applicant. Let's move on. We had tried to deal with 19. Are they back? Okay, let's go back to 19. All right, so 19 is 160, is this right? 167 Downsview Avenue. To alter existing one-story dwelling by constructing a front, rear, side split addition. It's 5 variances, including eave projection, driveway width, chimney width, and there's also east side yard setback. Staff report is negative, asking that variances 1 and 4 be refused. We've got no residents here opposed to this, but let's hear from the applicant's agent. State your name, address.
Hello, my name is Bevan Gray. I'm the designer and the architect or applicant for the project.
Okay, so before you get going, are you making any changes?
So I propose I can remove the chimney, so number 4, the chimney breast, we'll reduce it to no wider than 2 meters, not needing the side yard variance for 1.49 meters.
Okay, so
And
let's get this.
and number 3, pardon me?
Okay, so what's the first one you're doing? You're doing the chimney width. Which one?
So the chimney breast, so the variance is if you're any greater than 2.2 meters, and we will reduce it to being smaller than that.
You're gonna make it down to 2. Is that right?
Yes, we are.
Okay, so what I'm following the public notice, which it meets the hearing chimney breast variance number 3. Let's just be careful so we get it right. But we go,
Okay, so sorry.
Okay, so chimney breast down to 2, no wider than 2 meters.
Down 2 meters, no wider than 2 meters. Yes.
Okay, well, so you deal
And the one variance in regards to the driveway width, that's an existing driveway that's going to remain.
You're gonna leave it at 3.98.
Yes. Again, it's an existing driveway. It's been there for
So that's variance
many years.
number 2, is it? But the staff had a concern about the eaves projection and the east side yard setback. Am I wrong?
Yes.
They said? So what do you?
No, those are going to remain.
Those are going to remain. So you're.
Yes.
So effectively, number 3 and number 2, you're meeting. So those you're not here on those anymore. You're just here on 1, 4, and 5. Is that right?
Correct.
Okay. Okay, so we understand. All right, I think we're going to need a presentation from you. There's nobody opposed to it, but you're not in keeping with the staff report, so why don't you do your presentation? You'll have up to 5 minutes.
Okay, before we started this project, we actually tried to design to be within the existing zoning bylaws. And we designed a new structure using our meeting the existing bylaws. And we could not meet those designs within the financial feasibility of my clients. So after we went to the second round of designs, we came up with what we propose now, which is altering the existing structure to, again, try to get everything that my clients wanted in regards to designs, but also adhere to, as best as we could, the zoning bylaws. We went out to all the immediate neighbors who we have support from. We've changed the designs from our original designs to try to adhere to what the adjacent neighbors wanted us to do. And again, now they have letters of support from everybody around the neighborhood to basically support what we're proposing to do.
Is that it? So you're done your presentation? Anything else?
Yes, I am.
Okay, thank you. Do we have questions from the panel? Mr. Allison.
Thank you, Mr. Chair. To the applicant, is there anything that would prevent you from providing an additional setback on the east side yard?
So basically, the east side yard, we're trying to not. It has to come down to feasibility for financial reasons. Where the existing exterior wall is that we're trying to build on top of. Like I said, we tried to redesign a new structure that met all the zoning bylaws for the city of Toronto, but it was cost prohibitive for my clients. So we're stuck with we're trying to work with the existing side yard setback of the one wall that's on the east side setback, and then we're trying to give them what they want within that structure. So, like I said, if we designed a brand new structure from scratch, it was adversely affected their financial budget and they couldn't do it. And this is like kind of what we could do to come within what they wanted.
Of course. So there's you're stating that there is a wall that is already there that you're building on, or a foundation that you're building on at that setback?
Correct. So basically what we did is like we tried to design to meet within the existing zoning bylaws, and we came up with a design, and it was financially not acceptable by my clients that we could not feasibly build that. So then we worked back to using the existing structure because they're a family of five, family of five, and we're trying to fit them in the structure. So we, based on not being able to build brand new from scratch, we worked the existing structure. The side yard setback to the garage and the property line is what was presentable to them and which they accepted. And we also proposed it to the existing neighbors on both sides, and they agreed that what we're proposing is, acceptable.
Could you identify that existing condition for us with the east side yard setback?
What do you mean by?
Because I'm looking at the site photos that are in the file, and it just seems like it's an open space.
Yeah.
So and I understand you're dealing with existing, but I'm just trying to get a better understanding.
That is an existing space, so there is nothing there right now. It's open driveway, but part of my clients, what one of their wants that they have to have or want to have is an attached garage for safety reasons and coming in and unloading the kids and stuff. They have 3 young kids and they want to connect a garage with a doorway into their existing structure.
Okay, so it is essentially it's a new structure attached to the side, And the width
Correct.
of that, and is there anything that would prohibit egress or access of a garage on the side with an increased setback, or are you already at the minimum to get that garage in?
To get the garage in, actually have a space where you pull in the car and then have a somewhat safe. It's only 30 inches I have from the edge of the car to the wall inside the garage to have them, move room to move. So yes, I could come a little bit more in, but you're really decreasing the amount of usable space inside the garage.
Okay, thank you.
Alrighty, anybody else have questions? You want to come into committee? Let's go into committee. We have a motion on this, maybe? Anybody like it? Anybody want to discuss it or put a motion? Again, there's no residents here in opposition. It is against planning.
I just want to make a comment through you, Mr. Chair. I am not quite convinced with the east side yard setback. It's labeled as two-car garage, whereas it's not really a two-car garage. And we have also a very small setback on the other side. I don't get why the applicant is seeking this much, close to the property line on both sides.
We're in committee. Well, I think it's interesting that nobody is here to oppose it, right? Like, you would think those neighbors would oppose it. Why they're not, I don't know. I mean, the 401 runs right behind this, right? If you look at, so it's kind of a mix of stuff there. I don't know. Go ahead, like, you want to propose a motion?
I don't want to make a motion. I'm just raising my concern because.
We've had instances where, and I think this committee's been very lenient, where you have existing homes that are trying to work within what they have, which is why I asked the question about the garage. In fact, we had one specifically where there was a garage added to the side, and it was very tight, but that was the only option to essentially get to actually have a garage. In this case, I think they're taking a few liberties with the garage width. I think it could benefit from a slight reduction to improve the side yard setback. And while I do appreciate, the desire for access within the garage, I also, we have to think about access along the side of the building. 0.58 meters is pretty tight for access. So I'd be happy to bring a motion to approve the subject application with the modification to variance number 4 to increase the east side yard setback to 0.9 meters, which I think would provide at least kind of functional relief between the fence and the house, that you could provide access without someone or something getting caught in between there. With respect to the eaves, I think 1.7 meters, does that take care of the eave projection? Sort of irrelevant if we deal with the variance number 4, but I'm happy to put that motion forward if there's no other comments.
So let's make it clear. So the applicants has 1, 4, and 5, right? So it's to approve the application as modified. And what are you doing with the?
It was variance number 4. My colleague brought up of concern. I share the same concern, and I think it's reflected in the staff report from planning.
Right. Okay. So, and what's the number that you're using there?
0.9 meters.
0.9.
It's a slight increase, but I think when you're dealing with such a tight space, that difference at least accommodates access through a side yard.
Right. So 0.9. Okay. So we got a seconder. Motion, yeah. And we're not touching 1, which staff wanted touched, right? No, for now. Okay. So we got a motion, we got a seconder.
Yeah, and so,
Anybody else
sorry,
wanna
Mr.
talk?
Chair, are we're accounting for the modifications made earlier by the applicant, the removal? Okay.
Do we need it, what was the staff report? The staff report asked for it to be tied to something. Is it substantially in accordance with the east side yard? Oh, I'm looking at something else here. What am I looking at? No conditions, okay. So all those in favor of this motion? All right, so it's approved. All right, let's go to item number 21. Item number 21, congratulations to the applicant on the modifications. It's 115 Sandringham, 4 variances, proposal to construct new dwelling. Got an arborist report, a forestry report. 4 variances are east side yard setback, west side yard setback, building length, and lot coverage. Got nobody in opposition. Let's put forward the agent. Please. You have the agent on?
Hi,
Hello.
this is Danielle from Justin Sherry Design Studio.
Okay, and your address?
Yes, it's 17 Point Street in Barrie, Ontario.
Thank you. Any modifications to this application before you get going?
Nope, it's the same as that the zoning notice explains.
Before you get going, I know you've got your light on, Mr. Allison. That's not intentional. I just want to look to my left and look to my right at my fellow panel members and see a heads shaking means that they are not in a need to hear from the applicant agent, but do I see more head shaking? I don't see everybody's head shaking. I see grimacing. I see smiling. I see fidgeting. I don't see clear directioning. Just a second. We're seeing if we need to hear from you.
You can focus it to
Anyway,
specific
ask
questions.
We're
Okay.
gonna ask some questions.
I just had a question with respect to variance number 2 for the west side yard setback. You can provide just a few comments, planning rationale, why you're seeking that reduction.
I think the main reason that we felt comfortable requesting the side yard setbacks is because they're actually an improvement of the existing single-family dwelling that's there.
I recognize that they're improvement, but they're only, you look at the existing building and that improvement is, slight, right? The existing building, that reduced setback is only for a short portion, right? If we're a significantly larger building, that side yard now goes back almost 3 times what the previous did. You know what I mean? Like I'm looking at on the west side, it's just there's a substantial step back as the building goes further back. In this case, we've got that side yard setback that's being asked for it is being deployed across pretty much longer building length. Where we also have a variance for an additional 1.9 meters.
Yeah, so, oh, sorry.
No, go ahead.
Okay, we're just working through the clients, working on the design that they're looking for. This is, kind of what came together with the sizes of the rooms, the layout, given the flow, things like that. We are open to, if you do have kind of a specific number that you'd like to see on one side or the other, I'm sure the clients would be okay with, shrinking something here or there in their plan.
Well, I mean, I just asked a question now. I mean, I don't see any opposition from the neighbors. I'm curious to what my colleagues think, but, just trying to expedite the process, move it along. I'm just curious, perhaps they've got comment or none with respect to that.
So you want to go into committee and hear comments, or do you want to see questions? Hear
If they have
just
questions
ask
about
a question of the applicant. Did you look at other houses in the area to see what setbacks had been granted?
I personally did not. Justin Sherry, I'm sure would have. And I'm sorry that that's the answer, but being honest, I personally did not.
Okay.
Okay. One more question. Any issue with any subsequent approval being tied to the substantially in accordance with the site plan? And the reason I'm asking is because there's some variances for building depth, and I just want to ensure that I accept that it's only for a portion of the building and not the entire rear main wall, and I just want to make sure that there's some guides there should that variance be approved.
Yeah, sure. We're open to your comments.
Okay, no further questions.
You need to hear from the, based on this, does anybody need to hear from the applicant? So applicant's agent, you don't need to do a full-blown presentation because the questions have sort of satisfied the panel in terms of their thinking. You're welcome to take your 5 minutes, or you're welcome to articulate anything that you feel we might need to take into account once we go into committee, but the panel has indicated we don't need to hear your presentation in full. Are you okay with that? Do you want us to go into committee?
Yeah.
All right.
Yeah, that's fine with me. I think just the last comment I would say is, again, with the setbacks, honestly, it's probably because from the street, we see that it is a bit of a reduction. I know, like you're saying, the length is still much bigger than the existing, but I think from the street, it'll still look modest compared, to the rest of the neighborhood.
All right. So let's go into committee. Are you
happy to bring a motion?
Okay. So Mr. Allison.
Thank you, Mr. Chair. Happy to bring a motion to approve the subject application with the condition of urban forestry number 2.
All right. Any other?
As well as to tie it to the site plan.
Substantially
in accordance with the site plan. Thank you.
And I would just like to add, these plans are really well done, probably the best ones we've seen today. So to the applicant, well done.
Okay.
I guess you'll second my motion then?
Seconder, and your
and I second the motion. I thought I already said that, sorry.
Okay, so we got a motion, we got a seconder. I don't see anybody itching to discuss this, so let's put it to a vote. All in favor? And it is approved. Congratulations. Let's move on to the next one. Approved with, tied to site plan and so forth. So our next one is, what do we have? 22. 22 is 50 Wigan, 8 variances, constructing a new detached dwelling. We got an arborist report, got a letter of objection, we got 4 letters of support, we got a staff report, which is negative, recommending refusal of the application, opinion that the proposed lot coverage and roof eave protection are not consistent with the neighborhood. Let's talk about what these variances are. There's north side yard setback, south side yard setback, front platform encroachment, second floor platform encroachment, and a few others. All right. For 22, we do have some people who are neighbors and so forth, so we're going to have to hear from the applicant. Is the applicant's agent around? Please.
Yes, good evening, Mr. Chairman.
Hi there. So what's your name and what's your address?
Franco Romano, registered planner, 321 Lakeshore.
Thank you. What about the, given the comments, are you making any changes to this application?
No changes, thank you.
Okay. All right. Why don't you go ahead with your 5 minutes, please?
If staff can bring up my presentation slides, please. While staff is hopefully bringing that up for us, I will say that Ms. Mercurio is a longtime resident and owner with her parents of the property, 34-year resident, been there since 1990. She has received 30 letters of support, including neighbors to the north, west, east, mostly to the south. The south abutting neighbor has concerns, 97-year-old person that has some concerns being expressed by their son. And I do have a map of support letters there that staff is bringing up, but I'd like to go to slide number 1. We can go to slide number 1 of my presentation. We'll see on the upper side of the slide, these are the side elevations, and the staff concern with the eaves projection is at the far left and far right of that top part. It's basically the front portion. And if you look at the lower right-hand side, the rendering, it is the left-hand side, that front eaves that slopes down in the hip roof. That eaves is a variance, but it's a fairly modest variance, and it's an architectural component of the dwelling, which is an important one. There is the porch, and then there is a platform above. There is no size variance for that platform above in the front. I know the neighbor to the south indicated that there was a concern with a rear balcony, but there is no rear balcony. The lower left of slide number 1 shows the site plan, and the existing outline is shown there. So the 2 side yard setbacks. The first one is a north side yard setback, and that abuts a neighbor that's in support. The difference between the existing nearest side wall and the proposal is 3 centimeters. On the south side, the difference between the existing side yard setback and the proposed side yard setback is 29 centimeters. So it's not a significant difference. And I have reviewed the neighborhood, and the street itself side yard setbacks that range from 0.1 meters to 4.8 meters. And the majority of them are smaller than 1.8 meters. The prevailing is about 1.2 meters, and the proposal is 1.55 and 1.24. The proposal is in keeping with and consistent with the street and the neighborhood. In terms of lot coverage, the existing lot coverage is at 33%. The proposal is at 38.65%. That is, if we stay with slide number 1, please. Stay with slide number 1, please. So this is the blue. The blue is 33. The proposed is 38.65%. That represents a quantum of 31 square meters, or about 334 square feet. It's not a significant difference from what currently exists. And the lot coverage ranges on the street up to 42%. Recent approvals, including on the adjoining street, are at about 38 to 39%. 34% of properties on the street exceed 30%. I know my cover letter said 25%, but I revisited that, and it said it's 34% of properties exceed the 30%. So what is being proposed here is very sensitive, compatible, results in no unacceptable adverse impact. It's very clear that what is being shown here in terms of building height, it's lower than the overall height. It's lower than the overall permitted wall height. The first floor height is only at 0.9 meters, very ground oriented. The rear deck is 1 step up from grade level, and the building length is less than 17 meters. So this proposal really fits in not only to own the property and be sympathetic to neighboring properties, but it's compatible and reinforces the existing patterns. Slide 2 just summarizes what I provided in my cover letter for the variances. And slide number 3 shows the properties and the buildings, and we'll see that even when we round the bend from Wigan Crescent to Quincy Boulevard, buildings along the Quincy Boulevard in particular, right across the street or kitty corner, they occupy a lot of the lot. So those are lot coverages that I did not even count in my the properties that I provide.
Your
the
time's
evidence with.
coming to an end.
So subject to any questions, sure, I submit that the variances are minor in nature. Thank you.
Questions?
I have a quick question from the applicant. Wonder if you had a chance to discuss the refusal suggestion by the staff with them, because I see the memo is dated August 6th, so it's been like 11 days. So did you have a chance to talk to them about that?
Yes, through you, Mr. Chair. Thank you for that. Thank you for that question. That staff report came as a complete surprise. Usually the typical protocol is for staff to reach out with any comments. They did not reach out with any comments. I did ask the staff person as well as the manager, and the manager simply asked the staff person if they contacted me to discuss any revisions, and we've received no response. So it's a bit of an unusual situation, but thank you for that question.
Okay, thanks.
All right, more questions? No? Okay. Let's go to we got some residents here. Who do we have? Wants to speak to this? We have people, nobody in person, right? We just got online? Go to okay, so. Who's online?
Through the chair, we have Martin Strauss.
Can you hear me?
Yeah.
Hello?
Yes, go ahead. State your name.
Oh, okay. If you want, you can put me on video, so I'm not just a voice. My name is Marty Strauss.
And your address? Hello, can you hear us?
I can hear you. Can you hear me?
Yes, I asked, what's your address, please? Just for the record.
Yeah, 48 Wigan Crescent.
Okay. So go ahead, you've got 5 minutes.
Great. Thank you very much. I'm the son of Russell Strauss, who owns 48 Wigan and has been living there since 1952. He is the original owner of the house, and on the deed is my father and myself. 48 Wigan is just south of 50 Wigan, and basically of all the different homes on the street, there would be the most impact if the variance were accepted. I thought that there were quite a few variances requested, and just to make you aware, Thursday, August 1st was the first notice we got from the City of Toronto about the request for building. There was no sign posted. Nobody had discussed it with us before. And what we found out is that 1 week later, Thursday, August 8th, we needed to have submit our opinion. I contacted my lawyer that Thursday. He responded Friday night in an email, said, you better get a planner to understand all of the variances. Holiday weekend. On Tuesday, I contacted a planner, and the planner told me the same thing that I sort of saw from the meeting so far, that when you request variances, it really depends on what the neighborhood is like, privacy, aesthetics, and that in order to do a report, basically they've said it would take 4 to 6 weeks in order to give an intelligent opinion about whether 50 Wigan is asking something reasonable or not reasonable. And that is the main reason I'm asking now to defer any decision on these variances for at least 4 to 6 weeks so I can retain a planner and let them have a look at it and get their opinion. Regardless, the concerns that I have is that primarily the front of the house is being moved forward 2 feet closer to the street. It affects sidescape. There will also be a balcony on the new second floor. Again, affects the streetscape, and there will be a canopy on top and basically overview my father's house and the side property. I also got the feeling that the back porch also will extend fairly significantly in their backyard and affect privacy. One of the main concerns I have is the side yard lot line, They're just north. My father is south, and they would be moved about almost 2 feet closer to the lot line and build onto a second floor. The implications of that is that basically looking over the side property, looking over the distant backyard, my father has a window on that side, it would affect it. But one area I do have concern about is that if one day we were deciding to redevelop the property, would any of these variances given to 50 Wigan in any way negatively impact on 48 Wigan if we wanted to redevelop similarly? So I'm a sort of due diligence guy.
Sorry, I just want to interrupt you. Maybe just stop the time for a second, because I know you had asked us to put you on, and we can't see you. Is this intentional, or is there something with your camera?
Oh no, I didn't even. Oh no, I didn't even see the button. I think I have to do the button.
There you go. So I'm sorry about
Can you-
that. I just
Yeah, no,
realized
yeah, no
because I know
problem.
you went to that trouble, and so I don't think we can give you extra time, but at least we'll get to see you for your last minute and a half. So go ahead.
Right. So you know what? The bottom line is, if I would have known about this project weeks ago, I would have hired a consultant to take a look and say, this is reasonable or not reasonable, or look at what other variances done. But I wasn't given the opportunity, and I doubt any of the other neighbors were as well. And that's what I'm respectfully asking for the committee, that I should be able to hire somebody and get an opinion compared to the area, just like you had other people present, looking at all the variances asked for, and they did it methodically in that regard. So those are my thoughts.
So we just one thing. So I mean, I look at this and it says that there is a in terms of the notice, where we got public notice, signed posting affidavit. So it says it was posted on August 5th.
No, it wasn't.
Was it not?
Oh, August 5th it was.
Yeah.
Okay. At their house, we received notice from the City of Toronto by a letter on August 1st. There was no posting outside the home. And as far as my understanding, my sister went by the house every day. It wasn't until August 5th that there was actually a posting on their property.
Right. But
and we had to submit by August 8th.
Right. Well, okay. Yeah.
And especially now you've given the context that the city has major concerns as well. I think it should be definitely deferred and let everybody do their due diligence.
Okay, any other questions for the resident? No? All right. Okay, thank you. We have a counselor. Who do we have? Who else do we have on the line?
Through the chair, we have Linda Atlin.
Okay. All right. So would you please come forward, state your name and address? Hello? 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 Yes.
Hello?
Hi there. What's your name, please?
Oh, I'm Linda. I'm Marty's sister, so he was representing both of us.
Oh, he's representing both of you. Okay. That's fine, because it's in relation to the same property. Got it.
Yes, it's my brother,
Okay.
so we're together.
You don't have anything to say then. Fine.
No.
Thank you.
Everything.
Okay, so let's move on to the next person. We have a counselor who's on our list. Is he going to speak? No, counselor is not speaking. Okay, do we have anybody else? Any other residents who want to speak? All right, so the applicant, if you want, you can rebut the resident. Please limit anything you say to things that the residents said.
Yes, thank you for this opportunity, and thank you for Dr. Strauss's interest. My understanding, Dr. Strauss does not live at 48 William Crescent, but his father does. And Ms. Mercurio has reached out to the owner, Mr. Strauss, at 48, as she has with everybody else on the street and in behind. And that's where she's received those 30 letters of support. The building moving closer to the street is actually where the minimum front yard setback line is to be located. So there is no front yard setback variance. The balcony on the second floor is at the front, and I show that in the rendering on slide 1. I think it's a tastefully done, well articulated part of the building. We can certainly put screening on the south side of that balcony, but it is off of a bedroom. In terms of overview, the only window on the north side that has, or sorry, the south side, is an ensuite and an open area loft. There are no overlook issues, and care is being taken to make sure that the windows do not align with the windows to the south. The back porch is 0.9 meters off of grade, so it's very close to grade. It's not elevated in any way, but we can certainly put a privacy screen on the south side of that as well. The side yard setback is not 2 feet closer. It is 11.5 inches closer. It is 29 centimeters closer, and that is a substantial difference. I know it's 2 stories, but it's in keeping with the existing physical character, which I've described earlier. There are no negative adverse impacts that result from the requested variances to the sites. So subject to any questions, or submit that the variance request is minor in nature. Thank you.
Through you, Mr. Chair, a question for the applicant. What was the rationale for doing the 1.55 on the north and the 1.24 on the south? And second to that is, did you ever give consideration to splitting the difference and making them equal?
Thank you. Thank you for that question. The rationale is that it's an irregular shaped lot. It looks like a rectangle, but it's not, because it's right where the corner is. So the 1.55 on the north side, if you see where, I know it's unusual, the neighbor on the north, that's where De Quincy starts. That address is 110 De Quincy. But you see that they are set further back from the front lot line. So the rationale is there to give a little more space there, because it really is right where that building is, as opposed to on the south side. In terms of splitting it, I mean, there's various ways to do it. It could have been 1.2 and 1.2 on both sides, but we think that this is a reasonable approach and in keeping with the neighborhood and the street character.
Okay, thank you.
You're welcome.
Mr. Allison.
Thank you, Mr. Chair. I'm having a little bit of trouble understanding where the front yard setback is coming from. When I look at both properties on each side, their setbacks significantly further. Maybe the applicant can explain why this building did not trigger a front yard setback.
Through you, Mr. Chair, thank you for that question. If you see 110 De Quincy to the north, there is a broken line which identifies the front lot line. Their front yard setback is 5.58 meters. So staff have brought us to a property map which shows, because Wigan Crescent, as we go north at Wigan Crescent, right at the subject property, it swings.
Yeah, it's just the way
And when it swings, the boulevard increases in width. So the front yard setback line of 110 De Quincy is further back
Okay, that's
somewhere.
abundantly clear now, but I mean, I hope you just understand, I'm looking at both of the structures and I just can't for the life of me figure out what's going on. So there's a bit of a unique condition there, with respect to the road.
Yeah.
Okay.
Yes, yeah, but it is by law compliant. It's set at the minimum front yard setback line.
Okay, thank you.
Okay,
You're welcome.
are we into committee now? Unless there's more questions, let's go into committee. Do we have discussion or a motion? It's Casson. Do you have something to say? No, yeah. Mr. Allison. Oh,
It's not a motion, Mr.
Yes.
Chair, but I see that the support letters are almost worded similarly.
right.
So,
Is that a motion or?
no, not a
just
motion,
Comment.
not a motion.
So, yeah.
I think that's pretty common. I
Went
mean,
out and talked to the neighbors and they all signed.
yeah, it's pretty common for architects to canvass a street and show them the plans and get their signature. So I wouldn't read too much into it.
The architect, the consultant, basically sought letters, and that's what he got because he gave it to them. Right? Well, one thing I mean, there is opposition by one person, right? I can understand, like, you're just you're 97 years old, you want to just keep living there, for as long as you can, the same way. But, on the other hand, I think, what are they proposing? It's a nice big house, right? And that's going to enhance the value of their property somewhere down the line in, 10, 20 years when the owner passes away and wants to sell, and his relatives want to sell it. So I don't think that there's like a huge negative impact to them. I don't even know, what did they say, shading? Is there any issue about that? So I just don't see, yeah, sure, you don't want to be like a little house and have a big house next to you necessarily. But if you want to sell your house, you want a big house next to you because the person that buys your house is going to want to build a big house too. So it's not such a bad thing for them.
And the neighbor to the south was concerned that they would be able to do something similar on their property. I think that's why one of the reasons for the deferral was to consult a planner to see if that was possible. And, we can't speak to that, but obviously anyone can apply to build a new house and meet the bylaw or not meet the bylaw and make an application to committee.
Yeah.
So.
I'm not. I'm not sure. Look, what is the? What are the plans here? I didn't think that they were building anything completely ugly or anything like that. Well, I don't know. Oh yes, I see what it is. I'm missing things. Okay. What is this? This is, hold on, what are they doing? The front elevation on the rear elevation. Okay, I see. The front elevation looks okay, but it's not for us to decide beauty. We're just here to decide planning. So, come on, guys, let's have a motion. I don't quite understand why what the concerns are with the planning staff either, right? I'm not quite sure what it is. Somebody help me out, because I want a break.
I'll bring a motion. I frankly, I was a little bit thrown by this planning staff report. I'm trying to understand. They're recommending refusal. Usually there's good reason. That combined with the fact that the road just kind of does this really weird jog, which opens up a for them to basically build as far forward as they did. So I struggled a little bit with that, but looking at everything in its entirety, I do feel like the application as presented is supportive. So and a lot of the encroachments, I mean, they're certainly minor. We're talking about a 0.0, 3 or 4 in some cases, and that's really only as a result of a reduced side yard setback in a lot of cases. So, for those reasons, I'm happy to bring a motion to approve the subject application with the condition of urban forestry number 2 and urban forestry number 3.
Okay, so we got a motion to approve with urban forestry number 2 and number 3. Do we have a seconder?
I second that.
Okay, Mr. Marziari. Let's put it to a vote. All those in favor? Okay, so it is approved. Congratulations. I'd like to take a 5-minute break. And we'll be back. I think we have 25 is waiting for us, right? They're waiting here. I think we'll hear with them next.
Through you, Mr. Chair, we only have 3 items left and none have speakers. If we could just finish, that would be great.
Well, no, I'm taking a break. All right. Because I need a break. Thank you. Okay, we are back. Are we, the audio, video on? Let's deal with number 25. Number 25 is, and those are the people, that's you? Okay, so that is 140 Nipigon. Two variants, proposal to construct a new dwelling. We have an arborist report, we have a forestry report. We have 8 letters of support. Two variances, proposed side yard, soft landscaping area, and the proposed height of the side exterior main walls. Before you speak, I know you've been waiting there patiently, and you can get your 5 minutes if you want it, but I want to see from my colleagues whether they really want to hear you. But while you're up there, just state your name, state your address, then just pause, and then I'll Okay. So before we get going on this.
It's on, sorry. Good evening, Mr. Chair and members of the committee. My name is Alberto Cama. I'm the owner and applicant on file for 140 Nipigon Avenue.
All right. So, panel members, we have a question. So
Sure.
you may or may not want a presentation. We've got a question, so let's start with that.
So do you know how much the front yard and rear yard landscaping, are you meeting the bylaw requirements there?
We are, as a matter of fact, for the front yard landscaping, we are almost double what the bylaw says.
Okay, and you're meeting the rear yard?
We're meeting the rear yard and the other side as well.
Okay, thank you.
I also have a question.
Yep.
So if we approve this application, are you open, in regard with variance 1, are you open to make that side yard permeable pavers?
It is permeable pavers. It is,
So you're
as of
free to
right now,
include
yes.
that as a part?
Yes.
Okay, thank you.
Okay. Anybody else? No? All right. Before he spends 5 minutes of our evening, I'm looking to you to see if you need him to make this presentation.
Just a clarifying question. We can jump.
Okay. Question to the applicant?
Yes. Can you just point out where the 9.07 meter variance is on the building there?
Correct. So if you pull up the plans, so we are at about 7.5 meters for 77.7% of the wall, of the length of the wall, and only about 9.07 for only 22% of the wall. So that should probably be page 4, or sorry, slide 4, slide 5, maybe on the plans. If you go maybe next slide.
Keep going down.
Yeah, keep going down. If
more. Another
more.
5 pages.
Yeah, one more. I think should be next. There you go. So we're at, so it's only the back portion and only the front portion as well at 9.07. And almost 80% of the length of the wall is at 7.5, which complies with the zoning bylaw.
Okay, and on the parallel elevation is same condition, but I guess for a larger span?
Correct.
Let's just pull that up. That's facing the street, right?
This is the side.
The side, but the side that flanks the street.
Yeah.
There we go.
So this is facing the cul-de-sac on Whitman, which is the.
Okay. So the variance would apply to that wall as well, then?
No, just on the other side.
On the other side.
Yeah.
Okay. Okay. No further questions. Thank you.
Thank you.
Okay. Seeing no questions, do we still want a presentation? We do not. We do not need a presentation. Now, I know
Good,
you've
that's
been waiting
good.
patiently. You're probably itching to make a presentation, but what awaits you may be better than the presentation. So
Excellent.
you have to decide how you want to spend your time. If you're okay, we'll just go into committee.
Sure, I'm okay with not doing a
Let's go into
presentation.
committee. And I see Mr. Marziari itching to make a motion.
Thank you, Mr. Chair. I think it's a straightforward application. It meets the 4 tests. I'd like to make a motion to approve this application with inclusion of the permeable pavers for the side yard and also subject to urban forestry condition number 1.
Could I make a friendly amendment to that and tie it to the elevation? Are there particular elevations that we want to tie it to, or all of them?
Yes, of course, that's it.
So substantially in accordance
Substantially
with
in
the
accordance with
elevation drawings?
Sure.
Okay, and staff have that? Good. All right, so we got a motion, and that's a second, right? That's a second with the amendment, and all those in favor, and it is approved. Approved. Congratulations.
Thank you very much.
Okay, thank you. Let's go to item, I think we got item 23 to hear now. All right, let's go to item 23, and that is 217 Stiber, 2 variances to alter existing 2-story detached dwelling by constructing a rear 1-story addition. We've got a few documents on file, nothing's too significant here, but the 2 variances are altered dwelling length and floor space index. So we have the applicant online somewhere.
Yes, good evening. My name is Greg Papp, and I am the agent for the owner, and my address is 90 Thorncliffe Park Drive.
Okay.
Hopefully you heard all that.
That's, are you making any changes to this application before we get going?
No.
All right, let me just check the temperature of this room. I see some heads shaking, which means it's very potentially your lucky day. You do not need to make a presentation unless you want to. But
No, sir.
Okay, that's great. Let's go into committee. I see Mr. Allison.
Yes, through you, Mr. Chair. I think this is a pretty straightforward application. The variances are quite minor in nature, and they don't present any adverse impact to the neighborhood. For those reasons, I think it meets the 4 tests, and I'm happy to put a motion forward for approval without condition.
All right. Mr. Marzieri has seconded that. And all those in favor, and it is approved. Congratulations to the applicant. And let us go to item number 24, which is 3 Mogul Drive, 2 variances. This is to extend a house towards the south and construct a 2nd-story addition over a garage at its rear side. There's a few documents on file, nothing of burning significance. The 2 variances are proposed front yard setback and proposed south yard setback, side yard setback. All right, where's the applicant?
Hello.
Hi there, state your name, state your address, please.
My name is Albert Yerushalmi. I'm from Eden Engineering, the designer, and I'm your last applicant tonight.
We hope. Unless we get a write-in candidate, which we hope we do not get. All right, so are there any changes to your application?
No, nothing. One of them is a technical one, is existing, the front setback.
Okay. Let me just check the, I see people kind of nodding off here, which means I think that's going to be good for you. You don't need to make much of a presentation or any presentation. You want us to go into committee and do our business?
Yeah.
Okay, let's do
Sure.
it. We'll go into committee. Do I see a motion? Mr. Kubu is itchy to make a motion. I see it. Yes. Yeah. There he goes.
Thank you, Mr. Chair. This seems like pretty set for application which meets the 4 tests, and I will recommend that this committee approve the application without modification. Without conditions.
We've got a motion without conditions.
I'll second.
Mr. Allison. Those in favor? All right. Congratulations. It is approved. And we're adjourned.
Much appreciated.
Thank you. And
Much appreciated.
I know they love the motions for adjournment. We don't really need a motion because we have nothing left on our agenda, but if you want a motion, I see, I see, well, you only really have to note the time, but if it matters, then it's Ms. Casson seconded by Mr. Marziari. There we go. And it's unanimous. Thank you.